Am I good to start now?
Yes, go right ahead.
Great, thank you. Good morning, everyone. As Chair of the Children and Family Law Committee, I find that due to the state of emergency declared by the Governor as a result of the COVID-19 pandemic and in accordance with House Rule 67 and the Governor's Emergency Order Number 12 pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing on bills referred to the committee. An executive session may follow. Please note there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform, and the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting notice complies with House rules and RSA 91A. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. Christina Dyer is the staff assisting us. Please note that all votes that are taken during this meeting shall be done by roll call vote. Let's start the meeting by taking a roll call attendance. When each member states their presence, please also state where there is anyone in the room with you during this meeting, which is required under the right to know law. Madam Clerk?
Good morning, Madam Chair and CFL committee members. Representative Haltschiller. Representative Belanger.
I am present in my home. My wife is in the other room. I'll be going in and out periodically of the office.
Representative Marsh.
Good morning, everyone. I am present in my home office in Brookfield, New Hampshire, and I am currently alone.
Thank you. Representative DeSimone.
Good morning. I am in the LOB in room 210.
Representative Grossman.
Good morning, everyone. I'm in my kitchen and I have 2 remote learners today in the house and my husband.
Thank you. Representative LeVay.
I am here. I am in my sewing room alone.
Representative Lewicki.
I am in the LOB with the chairman and the vice chairman.
Representative Litchfield. Representative Long.
I'm in my house alone.
Representative Petrigno.
Good morning. I'm here alone in my home office.
Representative Smith.
I'm here in the house with 2 remote learners and my husband. I'm sorry, I'm here. Yeah, in my house. Yep.
Okay. And husband. Representative Wazir.
Yes, I am here in my kitchen with whole family.
Representative Yokella.
I am here in my home alone.
Chairman, Representative Rice.
I'm in the LOB, room 210 and 211, with my vice chair and Representative Lewicki.
Representative Ali Sayah, I am home with a puppy. Thank you.
Madam Clerk, I see that Representative Altschiller has come on.
Representative Altschiller. Are you
Good
home?
morning. I'm here in Stratham in my office and I am alone.
Thank you. Thank you, Madam Chair.
Thank you very much. All right. So today we are going to continue the public hearing on HB 317. And we will start the testimony with Derek Champagne. Mr. Champagne, if you could state who you are, where you're from, and who you are representing.
Thank you, Madam Chair. My name is Derek Champagne. I am a resident of Lancaster, New Hampshire, and I am testifying on behalf of the parents' rights movement in New Hampshire.
Thank you. Go ahead.
Hello, everyone. My name is Specialist Derek Champagne, retired United States Army. I served honorably from 2009 to 2015 when I was medically retired after being injured during a tour in Afghanistan in 2013. I came back stateside and went on to spend 2 years in the Wounded Warrior Center in Fort Drum, New York. I spent months learning how to walk again, underwent surgeries, and learned to cope with a whole new way of life. When I retired, I was evaluated and put on the permanent and total disability list. When I returned home to New Hampshire, I had no idea I would be fighting another war, one of which most fathers fight for years. In our current courts, I'm a loving father of 2 beautiful girls, one of which, after more than 2 years of court proceedings, I have 50-50 custody of. I am very happy to have my daughters in my life, and I felt like I could finally be a parent. Unfortunately, I was not prepared for the next obstacle I'd be facing. I thought when I returned home, my state would be proud and thankful to all of our veterans for sacrificing everything overseas. Just as proud as I was raised to be. However, I found faults in the state of New Hampshire. I have found faults the state of New Hampshire has illegally, according to federal law, been considering disability compensation and child support calculation. This is against federal law and the apportionment process and proceedings. Not only has this completely drained my finances, as well as many others who proudly serve, but it has left me paying $1,275 a month in child support alone. I have spent years digging myself out of debt that seems to never be ending, on top of dealing with my disability, and it is exhausting. I have job limitations due to the disabilities being so severe and an inability to work at times. This leaves me relying on Social Security benefits to assist me financially. After my child support obligations come out, I receive $411 a month to live on. My mortgage and vehicle payments alone are triple that. Until the crippling effects of this federally illegal action ceases, myself, as well as many other veterans who have been stripped of our rights to due process, will be forced to choose between paying their bills or seeing their child support ordered through. Honestly, being raised here, our state is better than this. Our soldiers deserve better. And as far as the Title 4D office needing the money, as it was stated last year, I believe that counting illegal funds in their budget to begin with should be questioned. I have made $15,403.20 this year in Social Security benefits alone, and I have only seen $6,285.60 only, less than half. And I would like to see the people in that office attempt to survive like that. That is it for my testimony. If anybody has questions, I would be more than happy to answer them.
Are there any questions for Mr. Champagne? Representative Belanger?
Not a question, Madam Chair, just a statement. Just wanted to thank the witness.
No statement. This is time for question.
Thank you.
Are there any further questions? Seeing none, thank you very much, Mr. Champagne.
Thank you.
Up next is Bjorn Bruckshaw, who has asked for 5 minutes. Okay, I don't see them on the list here.
Madam Chair,
Yes?
if when they begin to speak, if they will share, if they have a written testimony,
Definitely, thank you. I apologize, I forgot.
it's okay, thank you.
Up next is Jesse Bolin to speak in opposition for 4 minutes. Could you please state who you are, where you're from, and who you are representing, and whether or not you have written testimony?
My name's Jesse Bolin, representing myself. I live in Manchester, New Hampshire. Did I miss anything?
Do you have written testimony?
I do have written testimony that I can share once I've said it and send to the email group if that's okay.
That would be great. Thank you very much.
Thank you. So as I stated, my name is Jesse Bolin, and I'd like to start out by expressing my most sincere appreciation for veterans that have served this country prior to, and to preserve our freedom and way in life. So thank you. And I'd also like to thank the committee members for the opportunity to express my thoughts and feelings, and also to hold a separate session so that we did have time to do this. I'm just going to briefly explain why I'm in opposition to the bill. As the language states in the proposed bill, HB 317 seeks to eliminate counting disabled veterans' income as gross income. And when reading the text of the two reference laws, 42 USC section 659 and IM 9803, HB 317 would dramatically change the existing process for New Hampshire in calculating child support when either party is receiving disabled veteran compensation, essentially taking the power out of the hands of the family courts for resolving pay disparities and putting that burden directly on the taxpayers of New Hampshire. For example, if a 100% disabled veteran receives all of their income from the government, the other party would have to seek aid from the state of New Hampshire instead, in the way of TANF or similar funds. So I would put this question before the committee. Do you believe it is the responsibility of all New Hampshire taxpayers to pay child support to the ex-spouse of a disabled veteran? And so if the answer is no, I would implore you to vote inexpedient to legislate on HB 317. So next, the New Hampshire Supreme Court has already ruled on this matter just about a year ago on this in this exact case. In reference to, in the matter of Sean Bronstein and Jerica Bronstein, the New Hampshire Supreme Court roundly dismissed the case presented by Sean Bronstein, who also happens to be the original author of HB 317. By referencing existing precedent in both New Hampshire and federal cases. In essence, the New Hampshire Supreme Court found no existing laws, whether federal or in the state of New Hampshire, meant to exempt any compensation to veterans from child support. I've already submitted this as evidence to the committee for review in support of these statements. So, passage of HB 317 would have an adverse effect on New Hampshire residents, most directly those who receive child support will find that support disappear. And because income from all sources is considered, when calculating child support. If the ex-spouse of a disabled veteran happens to be maybe making more than the vet, it's possible they would have to pay child support to the disabled veteran. However, by this logic, people who make less would see their support cut, and those barely making ends meet now may face dire repercussions. So, and when those people have nowhere else to go, they will utilize New Hampshire support services, costing New Hampshire taxpayers. Lastly, I have known Sean Bronstein for many years. Jerica, Sean's ex-wife, who testified in the first hearing on this bill.
Mr. Boland, this is not about Mr. Bronstein. You're here to speak about the bill.
I understand that, but basically what I'm trying to get at is that the bill before this committee was written in spite of the fact that he could not get out of paying child support. And yes, he is a disabled veteran.
Mr. Boland, I have to ask you, you can't make those statements about another person. You're here to speak about the bill, and we'll decide whether the bill has merit or not whether it was written in spite or not.
Okay, I understand that. Then I will just, at that point, I again restate that in New Hampshire state law, they did say, in rejecting the argument that was brought before in Rose v. Rose, it is to reject the argument that it's a federal law to exempt child support by avoiding the possibility of Veterans Administration being placed in the position as a collection agency, and to prevent the deprivation and depletion of the means of subsistence to veterans dependent upon these benefits as the main source of their income. So, I mean, anybody quoting federal precedent is ignoring the fact that the Supreme Court of New Hampshire has already ruled on it and has put lots of time and effort and precedent listed in that ruling, which has been sent to you. So thank you for your time. I apologize for having gone in the wrong direction. I've never testified before a court before, so I apologize. Thank you.
Thank you very much. Are there any questions for Mr. Boland? Okay, seeing none, thank you very much.
Excuse me, Madam Chair.
Yes.
I actually had a question. This is Derek
Mr.
Champagne.
Champagne, no, questions come from the committee members, not the audience.
Okay, but there are systems in
Mr.
place.
Champagne, you have already testified. Up next is Sean Bronstein, who's asked for 3 minutes. Could you please state who you are, where you're from, and who you are representing, and whether or not you have written testimony? Mr.
Hello, good
Bronstein?
morning. Can you hear me okay?
Yes, could you please state who you are, where you're from, and who you're representing, and whether or not you have written testimony, and you have asked for 3 minutes?
Yes, ma'am. Before I do that, we actually, from the last bill, we were supposed to have Carson Tucker finish his testimony because he was cut off.
And I'm going in the order down my thing, and I had told Mr. Tucker last time he could not have an hour, and now he's asked for 30 more minutes. So when Mr. Tucker is actually after you.
Okay, thank you, Madam Chair. I appreciate that. My name is Sean Bronstein. I am a resident of Hooksett, New Hampshire, and I am testifying to this bill on behalf of myself and several other disabled veterans. And I did submit a written testimony to the committee as well. Thank you for your time in reviewing this bill. My name is Sean Bronstein, and I'm a disabled veteran and retired federal employee. You've recently heard testimony from my ex-wife, Jerica Bronstein. While I disagree with certain aspects of her testimony, it is not seen as portraying an accurate view. She has the right to share.
Mr. Bronstein, I would just ask that you speak to the bill.
Yes, ma'am, I am. I am stating that. I am not here to provide details of my contentious divorce, but I am here to bring insight on how my rights were impacted. To address the elephant in the room, this bill is not about not wanting to pay child support. At no time did I or any veteran refuse to pay child support. In particular, the case which I filed in the appeal for the enforcement, it was an appeal that they would not enforce the order at child support. Unfortunately, this was false. After nearly 18 months of asking the state of New Hampshire Child 4D agency to file an apportionment, they finally did file the apportionment, but they failed to file it correctly. The Department of Veterans Affairs requested them to provide the correct form. Unfortunately, the state and my ex-wife did not provide this information. And when I asked them to submit it again, it was refused, and it was stated it was inappropriate and redundant to ask for a second request. How is this due process? These documents were submitted to you previously, which shows that the Department of Veterans Affairs asked the state to complete the apportionment process, in which they have not done so. This bill provides due process, which is protected under the Fifth Amendment of the U.S. Constitution and the 14th Amendment of the New Hampshire Constitution. It puts New Hampshire back in line with the federal laws, and it provides a legitimate avenue to seek a portion of federal benefits which are protected. Many people have read the decision from both the lower courts and the New Hampshire courts regarding my personal case, but they did not take the time to actually research the laws that both the courts pointed to. For example, in the lower court, the judge stated she was following the current state legislature that was produced. This is correct. She refused to comment on federal law. The New Hampshire Supreme Court used old federal statutes, specifically 383101A, which was changed after the Veteran Judicial Review Act of 1988 to 385301. Essentially, the New Hampshire Supreme Court cited federal statutes that are now considered vocational rehabilitation. Veterans are not asking to not pay child support, but they are asking for your help to enforce protection on their benefits with regard to taking into consideration that many of their injuries impact their daily living. And not everything is covered by the VA. The funds are protected and are to be used for this purpose. That completes my testimony. I've already submitted written documentation to you as well, and I'm happy to answer any questions that you may have.
Are there any questions for Mr. Bronstein? Seeing none, thank you very much. Up next is Carson Tucker. And Mr. Tucker, I know you've asked for 30 minutes, but I'm going to give you 15 minutes because you had time before. And we have a lot of business to cover today.
Yeah, I appreciate that. I don't think I asked. I'm sorry if it's appeared that I asked for 30 minutes. I'm fine with 15. It's perfect. And
Great. Can you just state who you are, where you're from, and who you're representing, and whether or not you have written testimony?
Yes, ma'am. I have submitted a written statement. I hope that you've all had an opportunity to look at that. It's and some other materials that are supporting that written statement. I sent it to the email that was provided. I'm an attorney, former Judge Advocate General with the Army for 12 years, also with the United States Navy enlisted before that for 14 years. And I'm admitted to the United States Supreme Court. I'm an appellate attorney. Since I quote unquote retired, started my solo practice, I have been representing disabled veterans across the country. I've also started an organization that assists the defense of disabled veterans and veterans' rights generally across the United States in terms of the issues that you guys are discussing today with HB 317. As I testified last time, and I'm very happy to pick up where I left off, because I think I would love to answer some of the questions and essentially questions from anyone that has any questions from the committee. I would really, really be happy to do that, because I think it's always great with oral argument in court and as well in these testimony situations. When people ask questions, we get a lot of information out of that. So I'll try to be brief with the remainder of my testimony. And I want to respond to one thing regarding whether or not and to what extent your recognition of preemptive federal law would actually be a burden on taxpayers of the state of New Hampshire. Statistically, as we spoke last time, nationally, 70% of the disabled veterans in the United States, of which there are 5 million, or 70% or greater disabled. However, there's only approximately 3,500 disabled veterans in the state of New Hampshire. Of that amount, I assure you, if you were to follow federal statutes as the HB 317 requests, it would not be a burden on state of New Hampshire taxpayers whatsoever, because federal law, under the provisions that were post 1987, which is post Rose versus Rose, the congressional statutes cited in my statement, 42 USC 659, 38 USC 5301, and the regulations that are also cited, provide through the federal appropriations process, right? Federal money is appropriated by Congress every single year for purposes of paying disabled veterans the disability pay to which they are entitled, and also to pay the dependents of disabled veterans for the support requirements that they have. This is why it's required to go to the VA to request that they make an apportionment of these benefits that they have appropriated through federal taxpayer dollars to pay to the disabled veterans and their dependents. All the HB 317 does is defer, which it has to under the Veterans Judicial Review Act, which again was passed post Rose versus Rose in 1988, to the VA secretary for making those determinations. 38 USC 511 provides that the VA has exclusive jurisdiction over all questions of law and of fact with respect to claims for benefits by dependents. Exclusive jurisdiction. After Rose, Congress removed the concurrent jurisdiction that the state courts had to make those determinations, precisely because it was economically burdensome on the federal government and the appropriations provisions by Congress to provide disabled veterans for the benefits to which they are entitled. So federal law has these provisions. The apportionment process, 38 USC 5307, allows for the VA to apportion benefits and pay those dependents support orders and obligations that they're entitled to if they show a need, but that need has to be litigated through the exclusive jurisdiction of the VA, which is why it's set up that way. Congress even created a separate Article 1 court that is for all appeals of these questions have to go through that Article 1 court. It's the Board of Veterans Appeals, then the Court of Claims, then it's the Federal Circuit, and then it's the Supreme Court. So if there are any issues with a denial of an apportionment claim, an Article 1 federal court was created to exclusively address those claims. That's important. It's a lot like bankruptcy, right? When you have bankruptcies, the federal courts take exclusive jurisdiction over all questions of bankruptcy. State courts do not have a concurrent jurisdiction any longer, and that's the significance of the changes that Congress made after Rose versus Rose, which again, as I said last time, did previously, as an anomaly, hold that the states were not preempted. And I think it's important for the committee to understand, under the constitutional structure, these laws that are passed providing disability benefits are passed pursuant to Congress's enumerated military powers under the Constitution. And once that is done, once that source of law has been established and has been numerous times by the United States Supreme Court, and United States versus Oregon is one of the cases, McCarty versus McCarty Ridgeway, Mansell versus Mansell, Howell versus Howell, Hillman versus Moretta, numerous cases throughout the last 200 years have demonstrated that the exercise by Congress of its enumerated military powers is the source of law for these disability benefits that are paid to veterans. That means that the Supremacy Clause preempts all state law that stands in its way, including judicial law. So to the extent that the state of New Hampshire or any other state Supreme Court disagrees, I think that the legislature of the state certainly has the authority to defer to the Congress, which is the federal legislature, and its enumerated authority under the Constitution and the Supremacy Clause. So, and I just want to assure everyone that there are provisions for veterans and the dependents of veterans to be taken care of. It just has to come from a regulated authority that has the exclusive jurisdiction to make that determination. Otherwise, you upset the balance. Buchanan versus Alexander is a case which really highlights this. The reasoning in that case behind the deference that state courts owe to the federal government when they are addressing and dividing federal appropriations must be adhered to. Otherwise, the federal government's authority and power would be basically left to the discretion of 50 states and territories, right? So if the states could come in and divide up these monies as they saw fit in the manner in which they believe they can, then it would really throw the federal appropriations process into disarray. And I believe if you read the plain language of the statutes I've provided, you will see how this deference to the federal authority is set up and established and structured under the Constitution. So really, that's all I have to say in that regard. Federal preemption applies. The state has the discretion and authority certainly to make sure that the state of New Hampshire is in line with federal law and preemptive federal law under the Constitution. And you know, to the extent that Howell versus Howell, which is the 2017 Supreme Court case, a unanimous opinion in which I wrote the amicus brief for Veterans of Foreign Wars, was completely and 100% consistent with not only Rose versus Rose, but also the current status of these federal statutes. It basically said the states remain free to take account of the fact that some military retirement pay and disability retirement pay might be divided by and between the former spouse and the military, former military service member through purposes in either child support, alimony, or property, right? But it has to be established by the federal statutes. And that's very significant because I would like for the committee also to understand something very important. You know, in the percentages of disabled veterans these days, a lot of people, I think 10, 20 years ago, look at veterans and say, okay, that's a retired veteran. He or she spent 20 or more years as a service member. They have a full-fledged basic retirement pension, and they might have some disability. The types of benefits that we're talking about are 100% pure disability pay. They're not retirement benefits. 90% of the veterans that are disabled that are present right now in the United States are not of those who have retired. They're not retirees. They don't even have a retirement pension, a disability retirement pension. And again, it's a bit confusing sometimes because these provisions that are established by federal law, the percentages that are out there, it's difficult because some of these categories are hard to understand. But 100% pure VA disability pay is not retirement pay. It has nothing to do with retirement pay at all. It's a disability compensation that's paid to the veteran as a result of their service-connected disabilities, regardless of whether or not they had enough years in service to retire. It's a completely different fund, and that's why it has to be sequestered, and that's why the VA retains exclusive authority and final jurisdictional control over the disposition of those benefits. And the states, frankly, are just not respecting that, and that's the challenge we had in Howell. I mean, Howell, the U.S. Supreme Court, overturned 30 years of state court case law that was being adjudicated that was contrary to federal statutes and federal law. And I'm not surprised. I mean, I'm not surprised that we're in this situation today with respect to the child support and the spousal support, because the states generally are going to adjudicate this in a manner that they believe is favorable, but in fact is contrary to federal law. And it just is the reality. So, you know, it's a state by state battle essentially. And I do think the legislature has the authority, the power, and the ability to go and look at these federal statutes to recognize the hierarchy of authority and control under the Supremacy Clause, and to abide by the Supremacy Clause in the federal statutes that are on the books that again are post Rose versus Rose 1987. Rose versus Rose has been legislatively abrogated by the federal statute, which means that they must be respected, regardless of what the US Supreme Court said in 1987. So if there are any questions, I'd be happy to answer them. Again, I think that's very fruitful if there are. If not, I'll close my testimony. Thank you so much for having me.
Thank you. Are there any questions for Mr. Tucker? Representative Long.
Thank you, Madam Chair. Thank you, Mr. Tucker. Are you aware of any other state that has this benefit, this waiver of child support?
So there are some statutes in some states that recognize that they must abide by the federal statutes. So yes,
Okay.
Texas, for example, if you look at, and I don't have the references to the precise statutes, but some of the state statutes say they must abide by the federal law, which essentially defers to the Defense Finance and Accounting Service to pay directly to the former spouse and or the dependents the amount of money to which they are entitled. And again, this, if it comes from the federal DFAS, right, Defense Finance and Accounting Service, they will only pay that to which the former spouse or the dependents are entitled. And that's fine. That's how it should be, because the VA knows and determines, what benefits are available to dependents and to the veterans and to the veterans' former spouses. But there's none, so there's no other.
Can I have a follow-up?
Sure.
Yeah, follow-up, Representative.
Yeah, thank you, Madam Chair. So I'm not hearing a yes, so I'm going to take it as a no. The second question I have is, with respect to service-connected disability, the dependent compensation, would that also be waived with respect to 317?
When you say waived, I think 317 defers to the federal government to request from the VA the amount of apportionment of those benefits that should be paid to the dependents. So I'm not sure what you mean by waived, Representative Long.
That would not be included in the calculation of child support.
HB 317 would defer to the VA to determine through the apportionment process, as it should, what benefits are being paid to the veteran should be available or made available to the former spouse and or the dependents. Now remember, the federal law 42 U.S.C. 659 H1B H1A25 and H1B3 42 U.S.C. 659 defines what is income and what is not income. And H12A5 actually defines what is income and what the federal government will count as income for purposes of child support and spousal support payments. That's already established by federal law. That's why if you defer to the VA and DFAS as to what is available, they will see that, recognize it, and pay it over pursuant to a court order. Under H1B3, however, the amounts that we're talking about, the pure VA disability pay, 100% disability payments compensation, are excluded. They're not counted as income. So the federal government and the VA, to which it should be the deferred authority deferred to, would not pay that.
Okay,
So
thank you.
Yeah,
Thank you
317
very much.
takes care of that.
Representative Litchfield.
Thank you, Madam Chair. My name is Representative Melissa Litchfield. I am in the LOB room. I am here with three fellow representatives, Rep. Lewicki, Representative Rice, and Representative DeSimone. Mr. Tucker, first I just want to say that I feel that the vets are very lucky to have you on their side. And I want to say that I'm super grateful to all the vets that are out there for their service, or I wouldn't be sitting here today. I also want to start by saying that all humans are equally important.
Representative Lewicki, you have to have a question.
Oh, I'm sorry. My question to you is, I am just curious, when we are talking about these child support obligations, are these children any child born to this veteran, or is this any child that is born prior to the disability, or does it also include any children born after the disability?
So the veterans have an obligation to report and record the quote unquote qualified dependents that they have, and that they obviously rely upon the federal government and the VA to determine the benefit structure and the amount of payments that they should get. So it applies to anyone that's a qualified defined dependent under federal law. If a veteran has a child, whether it's out of wedlock or from a marriage, a minor child, or a quote unquote qualified dependent, they are going to report that to the federal government. They're required to by law. I hope that answers your question. It would include any dependent of a veteran, service-connected disabled veteran, or a retiree, or any veteran, service member, or any service member. actually.
Madam Chair, may I follow up?
Follow up?
Thank you. Mr. Tucker, my question is not whether or not a child is out of wedlock. I feel that that is irrelevant to the topic. My question is whether or not this child was born after this veteran knew that they were receiving disability benefits.
Yes, the child would be included as a quote unquote dependent of the veteran if it's a child of the veteran. I didn't mean to make a distinction. What I mean is the dependents or minor children born to the veterans are considered dependents, and they're entitled to benefits. The veterans have the obligation, but in fact, they're incentivized to report their dependents to the VA. So there's no reason to exclude them.
Thank you very much. Are there any other questions for Mr. Tucker? Representative Lewicki.
Yep. Thank you, Mr. Tucker. I assume that you understand our dilemma. These children have to be taken care of, and we cannot make distinctions in law between one child and another. They have to be supported. And so how are we going to support them, and how are we going to have one law for all of the people in this state?
So this is my experience, and I'm very happy to answer that, because my experience with pre-divorce or current family law matters throughout the states is this. We approach the judge and the former spouse. We provide them with the forms that are required by the VA to be filled out to request the apportionment of
Mr. Tucker, we understand the process, but
Okay.
can you just directly answer his question?
I'm answering it. So the VA will make the determination, and it works through that process. It's a 317 requires the courts to request the apportionment. The apportionment will provide the dependents with the support that they're required to have, according to the calculations of the VA. So yeah, I mean, there's provision for it. It's in the bill, and I think it certainly needs to be understood that bill references that. It defers to the VA, and there are provisions for dependents to be taken care of. So it's not like you're excluding them 100% altogether by virtue of this bill. The process actually works. We've seen it work.
Do you have a follow-up? Are there any more questions? Representative Belanger.
Thank you, Madam Chair. Mr. Tucker, you stated that there was only a small portion of disabled veterans in New Hampshire. Can you provide to this committee the possible number of those disabled veterans who are affected by a child support payment?
Yeah, so I don't have that exact number, but you can imagine that the subset of the disabled veterans population in New Hampshire that are affected by this is actually probably percentage-wise small, which is sort of good and sort of bad, right? It's unfortunate because we don't get a lot of attention because in each case, in each state, some states like Florida, Colorado, California have a huge number of veterans and disabled veterans.
Mr. Tucker, but we're talking about New Hampshire, and I
New
believe
Hampshire.
that you answered his question that you
Yeah.
didn't have the information.
Right.
Are there any further questions? Thank you very much, Mr. Tucker.
Okay. All right. Thanks, everyone.
Up next is Warren Perry, who has asked for 10 minutes. Mr. Perry, could you please state who you are, where you're from, and who you are representing, and whether or not you have written testimony?
Thank you, Madam Chair. My name is Warren Perry. I'm the Deputy Adjutant General for New Hampshire's Department of Military Affairs and Veteran Services. I am located in my office in Concord, and I did submit written testimony. I would like to start by saying, based on our extensive research, well, actually, let me back up. The charge of the department is to support service members, veterans, and their families, and we take that responsibility very, very seriously. And we understand the importance of this bill and having good, honest debate about the bill on both sides. The department is not taking a position. Rather, our intent is just to educate you based on our research and our understanding of the issue. Based on our research, we have determined that New Hampshire's consideration of VA disability payments as part of gross income when determining the amount of child support is fully compliant with federal law. VA disability benefits are compensation for the veteran's impaired earning capacity and is intended to support the veteran and their family. So from that regard, we can determine that it should be counted as gross income when determining child support payments. You heard some testimony previously from Representative Graham, and in his written testimony, he put a schedule of payments that described both with dependent and without dependent rates in terms of the payment benefits to veterans with their disability. Passing this law would therefore exclude the intended purpose, right? The with dependent rate part of that, since it's intended for the family, this law would effectively exclude the calculation of child support payments, those VA disability benefits that are intended for the family. So, again, we reassert that we're fully compliant with federal law, and the disability payments for veterans with dependents is intended to support the veteran and the family. We know this is again, an emotional issue. You're going to hear terms like disabled veterans. We certainly appreciate the sacrifice that all veterans have made. You'll hear terms like child support, what a veteran is, and disability rating. There should be a distinction made between a disabled veteran and a disability rating. In my written testimony, I point out that there are some currently serving members of the New Hampshire National Guard who have a 100% disability rating, but it doesn't mean necessarily that they're disabled. The impact of this law would be to exclude that person who is still living a meaningful, active life from these payments, right? So, or from the calculation of child support in these payments. So, again, I think it's and I appreciate Mr. Tucker's testimony. I think it's clear that we need to continue to separate the issue of alimony or ex-spousal support and child support. The law is pretty clear about ex-spousal support and defines dependent as a family member. The ex-spouse is no longer a family member or dependent. Therefore, the disability payment is excluded in that alimony piece, but it's still absolutely compliant with federal law to include disability payments when considering child support. The apportionment process is, to my mind, our understanding of the apportionment process is that is a form of redress for the affected parent or the affected child. It's not intended to be the process. Apportionment occurs or is, a person is eligible for the apportionment process when an obligation is not being met. So eliminating the obligation would almost certainly eliminate the right to apportionment. So if there's no court order ordering the child support, there would be no basis for making an apportionment claim. So I know it's a complicated process, but that is our understanding of this. So again, this bill is not really about apportionment. Apportionment is a process that occurs when an obligation is not being met. So, there has to be an obligation to pay child support before the apportionment process can start. I would say I don't envy the position that the committee is in, and I appreciate their considered, their passionate and considered opinion when they choose to vote on this bill. But you have to, our position is we are federal law and court precedent make it absolutely clear that it's permissible for the state to include veterans' disability payments when calculating child support. I want you to understand that VA disability payments, as cited in court precedent, are, and they cite the intent of Congress that those payments are made for the family and the veteran, not just for the veteran. Alimony or ex-spousal support and child support are separate issues. Rose versus Rose is clear court precedent, and it remains current today. In fact, part of the court case of Mr. Bronstein, and if you would just indulge me for a second, I'd like to read you just the passage with regard to Howell versus Howell, you heard testimony early about. And and I'm quoting from the Bronstein case, and it says, husband is also mistaken to the extent that he argues Howell versus Howell abrogated Rose or overturned Rose. Howell addressed the treatment of the division of military benefits as property in a divorce, not as income to support the veteran's dependents. Howell did not address the calculation of a veteran's income for child support purposes. And then it goes on to say, nothing in Howell alters Rose or the holding in Rose that military disability benefits are not required to be excluded from the definition of income for the purpose of calculating resources a party can draw on to fulfill child support obligations. So and again, I don't want to rehear Bronstein, that's not my intent, or rehear Rose. I just want to say that was the decision, and we generally follow the decision of the courts when they rule on matters of law this way. I would like to just address the fact that we did some research on other states, and we found that of the 50 states, no state expressly excluded the inclusion of veterans' disability in the calculation of child support. In fact, 29 states, including New Hampshire, expressly include them. 14 states include the disability benefits generally, but not expressly include them. And it was not addressed in 8 states. So there are no states right now that are currently not calculating veterans' disability benefits when we're determining gross income for the calculation of child support. And I will just, I did submit my written testimony. I hope that you had an opportunity to review it. I'm happy to answer any questions.
Thank you very much. So I have like 2 questions. And bear with me because I don't know a lot about this, but so whose responsibility is it to apply for an apportionment?
The affected parent or the affected party.
So it's not the state of New Hampshire or the Division of Child Support?
My understanding is the initiation of the apportionment process starts with the affected parent and is assisted by the Bureau of Child Services at DHHS. I'm not an expert on that, on how the process initiates. I know that Karen Hebert is going to testify sometime this morning, and she may be able to answer that question in a more detailed manner.
Thank you. And just one more thing. So this bill does not force the state to request an apportionment. Is that correct?
I don't see that in there. I think the effect of this bill, ma'am, is to eliminate disability payments within the calculation for child support as gross income for child support. I don't see any part of this bill that would have the effect of requiring the state to request apportionment. I just think it would be, and I think it would be a process that would be arduous. It would be another step in the process. You know, my understanding of the issue is that the federal government really defers to the states on a matter of family law, and you know, trying to put the federal government in that process is a little bit awkward to my way of thinking. I mean, after I served for 28 years in the Army, and you know, we have rules about child support and other things, and making sure that soldiers are meeting their obligations when they're still serving. And again, the military prefers to let that be a process between the parties or the courts. So, you know, I don't see this law as, you know, is giving a requirement to the states to do apportionment. I see it more as a fact that we're just going to exclude the disability payments from the calculation of gross income.
Okay, thank you. Representative Belanger.
Thank you, Madam Chair. Mr. Perry, question for you, sir. Obviously, in regards to payments when a soldier is considered disabled, and there is obviously a calculation as to how much this disabled vet may receive per dependent. Is that taken into consideration when making child support payments? For example, if a child's payment is if the veteran is receiving I'm just going to pull a random number here, $9 per dependent, is that disabled veteran paying more than that $109 from child support payments?
Thank you for your question. I'm going to clarify. And so what you're asking is the difference between the dependent rate and the without dependent rate the only thing considered in the gross income? Can you clarify that that's your question?
Pretty much, yeah.
So the answer is it'll be the gross income, I believe. So the calculation for child support, and again, the folks, Karen Hebert can answer the question better, but it's gross income. So the entire disability payment would be considered as the gross income, and then the percentage of that based on the formulas that are made by the state would be the amount of payment that would be determined, the amount of child support payment that would be determined. That's my understanding.
Thank you.
Are there any other questions for Mr. Perry? Thank you very much, Mr. Perry. Up next is Karen Hebert, who has asked for 10 minutes. Could you please state who you are, where you're from, and who you are representing, and whether or not you have given written testimony?
Thank you. On behalf of the Department of Health and Human Services and the Bureau of Child Support Services, my name is Karen Hebert. I am the Bureau Chief and the State Child Support Director. And I am in my Concord office testifying today. I did provide written testimony to the committee.
Thank you. Go ahead.
Thank you. It is my intention to provide the committee with information that will aid in your decision making. I want the committee to know the department believes you should be fully informed with respect to the impacts of this particular bill. I will say that the department honors and respects the commitment that veterans and military members have made. In order for child support in New Hampshire is determined using the New Hampshire Child Support Guidelines, and that is under statutory authority. The New Hampshire Guidelines statute defines gross income very broadly as all income from any source, whether earned or unearned, which language follows federal child support regulation. The federal child support regulation is a requirement in the child support state plan, which is subject to federal audit and which the state is currently in compliance with. This federal child support regulation requires that the state's child support guidelines must provide that the child support order is based on the obligor parent's earnings, income, and other evidence of ability to pay that takes into consideration all earnings and income of the obligor parent. Basically, the state must comply with all federal regulations in the state plan in order to receive Title IV, that's a Roman numeral 4D, under the Social Security Act, Title IV-D federal funding and federal resources, and to avoid fiscal penalties. The state of New Hampshire relies on federal funding and federal resources that provide critical data and support and sources for child support collections. The state would not be able to successfully serve families without this funding and resources. New Hampshire receives approximately $11.8 million each year from the federal government, which pays for over 2/3 of the cost of the state program. The federal government also provides data to the state, for example, federal new hire information. It provides direct support and resources to our employer community. And it provides the Treasury Offset Program, which is a major source of child support collected for families, which was in fiscal year 20, $13.6 million. New Hampshire courts also receive federal Title IV-D funding to establish and maintain expedited processes for the establishment of child support orders. With this funding and resources, the state is effectively able to collect over $80 million each year for approximately 40,000 children. At present, the state is in compliance with the federal law and regulation as determined by the federal government, and as evident by the fact the state continues to receive Title IV-D federal funding and access to those resources. Excluding veterans' disability benefits from gross income in the determination of child support awards would also subject the state to other federal sanctions, which are fiscal penalties of up to $1.9 million assessed every year against the state's TANF block grant, as long as the state is not in compliance with the federal authority. If this bill passes, the state will not be in compliance and will risk the penalty assessment. The amount of child support in certain cases will decrease if this bill is passed, which will result in more families relying on public assistance, as was mentioned in earlier testimony. This creates a greater burden on assistance programs in the state and on taxpayers. Excluding veterans' disability benefits from gross income will also negatively impact the department's ability to recover public assistance expenditures in cases where child support is assigned to the department. This is an important responsibility of the child support program. The passing of this bill would ultimately reduce the amount of children of veteran obligors would receive. The bill would be particularly impactful on recipient families whose income is below the poverty level and for whom child support is often most, if not their only source of income, according to a 2018 study in New Hampshire. I ask that you consider the following. Veterans with child dependents who have a disability rating of 60% or less receive a benefit amount that is less than the guidelines' current self-support reserve amount. If this is a veteran's sole source of income, the child support obligation is $50 a month, which is the statutory minimum. However, veterans with child dependents who have a disability rating that is greater than 60% would receive a monthly benefit amount greater than the self-support reserve amount and thus be liable for support in New Hampshire laws and the current guidelines. For example, the guideline self-support reserve is presently $1,223 a month. Let's assume that the sole income of the veteran is the veteran's disability benefit for the veteran with children. And let's say that their benefit is at a 100% disability rate. Their benefit amount would be $3,263.74 a month. Under the current guidelines, the amount for the Family of Child Support Award would be $668 a month. Under the proposed bill, the guidelines amount would be $50 a month. If this bill passes, children whose veteran parent is earning an amount greater than the self-support reserve would lose the financial support they would otherwise receive under the current statute. The calculation of child support is the target subject of this bill, which is separate and distinct from federal and state authority on garnishment. The federal and state authority and case law on child support garnishment state that while veterans' disability benefits are exempt from garnishment directly to the VA, once these funds are received by the veteran, they can be used to satisfy a state's order of child support. There is an exception to the garnishment through the VA that is provided for in federal policy guidance that was released after federal memorandum in 1998 that was issued by the Administration for Children and Families. It includes instructions to states on how to send an income withholding garnishment to the VA, including veterans' disabilities and the definition of gross income to both determine a support obligation amount and to satisfy a support obligation are absolutely allowed by federal law and in accordance with federal and state case law. So how do we help veterans now? The Department of Health and Human Services looks for ways to engage with and work with parents, including veterans, who want to support their children but are experiencing barriers to comply with the court's order, in other words, paying their child support. The department is currently helping these parents using a variety of methods, including outreach activities and intervention services, and connecting them with resources that may be available to them. The department uses a debt reduction program to help address unmanageable past due child support. It also takes steps to ensure the parent's support order is right-sized and based on their ability to pay. When any obligor parent does not have the ability to pay, the Bureau can, at their request, review their court-ordered amount and the circumstances that are impacting their ability to pay. If the circumstance warrants an adjustment of their court-ordered amount, the Bureau can take it to court for them and request that the amount be recalculated based on their actual income. For example, if the original order was issued based on earnings several years ago while in active duty at a higher rate of pay, but now the veteran is earning, let's say, $1,000 a month in benefits, then the order should be adjusted in accordance with the current guideline statute. It is the department's experience that many paying parents are not aware they can change their order, or they don't know how to, or they cannot afford the court filing fee. We can and do help them with this at no cost. These services are available to veterans, and if a veteran does not have a case with the Bureau, he or she can contact us and apply for services, even if their order was issued in another state, or even if their order was issued in another country. We can help them. If this bill passes, the state will be at risk of not being able to provide these kinds of services that many parents, in addition to veterans, need. Thank you for giving me this time.
Thank you very much. I just have a quick question. If a parent doesn't initiate the apportionment process, does the division do that? Or what happens with that if a parent is refusing to start that process?
Thank you, Madam Chairwoman, for your question. It's a good question. And there's been a little bit of confusion with respect to apportionment and that particular process. Apportionment does not replace child support. If the receiving parent, in our case, in the world of child support, if the recipient of child support requests assistance from the Bureau to file a claim of apportionment with the VA, we will file the claim with the recipient parent. We have instructions that have been issued by our federal office specifically on how to do that. Does that answer your question?
Kind of. I'm just thinking because the apportionment would add to their income and give them money to be able to pay this child support. Even if more would have to come out of their gross income, at least they would have that little bit of extra. So I'm just wondering why someone wouldn't do that.
It's entirely up to the recipient parent to make that request. Honestly, it's our experience in the department that we do not receive that particular request. I'm only aware of one instance where we have received that request, and actually it was not requested by the recipient parent. It was requested by the paying parent. So it is not a commonly requested, not a common request. And I don't have any information if the recipient parent initiates such request for apportionment to the VA directly without the Bureau's assistance. That is entirely possible.
Okay, thank you. Are there any further questions for Ms. Hebert? Seeing none, thank you very much.
Thank you.
Up next is Matthew Hayes, who has asked for 10 minutes. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony.
Good morning, Madam Chairwoman Rice and members of the House and Children. House Children and Family Law Committee, on behalf of the Department of Health and Human Services and the Bureau of Child Support Services, I thank you for giving me the opportunity to speak about HB 317. My name is Attorney Matthew Hayes. I'm an attorney with the Bureau of Child Support Services, and I have previously submitted written testimony. I'd like to just start by talking about the child support process generally to give the committee some additional context. The Social Security Act 4D, Title 4D, requires that all states follow federal rules and regulations when establishing and enforcing child support orders. The federal law requires that all states establish child support guidelines for the purposes of establishing those orders. The New Hampshire's child support guidelines are codified in 458C, and they establish a uniform system to determine child support awards. The purpose of this chapter is not only to ensure uniformity in determining the amount of child support, but also to ensure that both parents share in that support responsibility for their children, according to their relative percentage of each parent's income. There is a rebuttable presumption that the child support award calculated under the guidelines is the correct amount of child support, but this presumption may be overcome, and a state court may deviate from the guidelines when a party shows by a preponderance of evidence that the application of those guidelines would be unjust or inappropriate because of special circumstances. There is included in the statute a special list or a non-exclusive list of circumstances that, if raised by any party or the court shall consider in making an adjustment that departs from the guidelines, either downwards or upwards. The New Hampshire Supreme Court has interpreted special circumstances as including only circumstances that are economic in nature and relate to the impact of a parent's financial condition upon his or her ability to meet the child's needs. The trial court must consider any of these circumstances in light of the best interests of the child. So with respect to federal law, as Director Hebert already pointed out, federal law requires that the state use all forms of income and that all forms of income be included in the child support guidelines. In accordance with federal authority, our statute uses a broad definition of gross income, and the New Hampshire guidelines specifically include veterans' disability benefits. I think it's also important to acknowledge that the New Hampshire Supreme Court has confirmed the inclusion of veterans' disability benefits as income for child support purposes, and that is consistent with federal law. Veterans' disability benefits, as was already pointed out, intended to provide reasonable and adequate compensation for both veterans and their families. The Bronstein case that was been cited a few times also cites US Supreme Court case, Rose v. Rose, in which Rose recognizes that, again, the benefits are not provided to support the veteran alone, that Congress clearly intended veterans' disability benefits to be used in part for support of veterans' dependents. I'd just like also to point out that the New Hampshire Supreme Court in Bronstein has squarely addressed many of the issues that were raised previously today. The New Hampshire Supreme Court has found through its analysis that Rose has not been overruled, and many other state courts have come to the same conclusion. Many of those state court decisions are also included in the Bronstein decision. The committee should also be aware that the obligor in the Bronstein case has appealed that decision to the US Supreme Court, and the Supreme Court has declined to hear that case. I know that I've cited some things that we've already discussed previously, so I would like to thank the committee for giving me the time to speak about this bill. I'm certainly open to any questions that the committee may have.
Are there any questions for Mr. Hayes? Seeing none, thank you very much. Up next is Timothy Penisak. He asked for 0 minutes, but I'll give you 5. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony. Mr. Penisek, are you there? Okay, so then we will go to Moira Ryan, who has asked for 0 minutes, but I'll give you 5. And please state who you are, where you're from, and who you're representing, and whether or not you have written testimony.
Yes, hi, my name is Maura Ryan. I'm here today to oppose HB 317 FN. I advocate for custodial parents, veterans.
Excuse me, Ms. Ryan, can you please state who you are, where you're from, and who you're representing, and whether or not you've given written testimony?
Sure. My name is Maura Ryan. I live in Londonderry, New Hampshire. I represent custodial veterans, military spouses, and military dependents. I worked for the VA, and I advocate on behalf of veterans with apportionment claims, which I've been doing for over a decade. Did I answer all your questions? And I did submit written testimony. I did submit written testimony, yes.
Okay, thank you. You have 5 minutes.
I just wanted to talk to the committee about the apportionment process. I've worked for the VA. I've been defending veterans against apportionment claims and also applying for them on behalf of custodial parents. I also worked with the VA DC office, and I wanted to explain what a veteran apportionment is. A veteran apportionment is a process in which a claim filed by the custodial parent requests money be paid for the support of a dependent. The apportionment claims were meant to be an additional means of enforcement of child support, not a substitute or relitigation of a divorce proceeding. The VA has determined that VA disability is meant for the support of the veteran and their dependents, as others have said, and it's cited in almost every veteran law decision from now decades back. VA General Counsel has stated that the purpose of the apportionment is to effectuate the responsibility of the VA beneficiary to support the beneficiary's dependent. Both the VA, the DOD, and all of the service branches state that the parent, regardless of service or status, is supposed to support their child. The VA has the right to determine the veteran's obligation. Mr. Tucker had said that the VA has the right to determine the veteran's obligations, but that's actually not true because the VA apportionment process actually relies on the state process. So what happens is the custodial parent will file a request for apportionment, and a general apportionment is granted if the veteran is not essentially fulfilling their obligation to support the child and if the child doesn't live with the veteran. One of the issues that I've had with veterans is that the custodial parent will apply for an apportionment claim and they will also be fulfilling their child support obligations. And then I have to go back and get that money back from the VA. And if there's no state court support order in place, it's going to make it existentially harder for me to defend them from people who do that. The fact that the apportionment process exists is because it's supposed to support the state process. It's not supposed to replace it. The same sentiment was echoed by the Supreme Court in the Rose v. Rose case, which is not outdated. Howe v. Howe, Wisner v. Wisner, and many of the other cases that Mr. Tucker had cited specifically reference alimony and divorce proceedings where assets are being divided. Child support is not an asset. I agree that once the ex-spouse is no longer a part of the family, they're not entitled to support, but the child still is, and the veteran still has an obligation to do that regardless of their status. All of the cases that he cited, Wisner, Howe, they all specifically state that they're not in relation to child support. The veteran does have a duty to support defendants, and honestly, if you take away counting that child support or putting in a court-ordered support obligation, it makes it harder for me to defend these guys when there are people who go and apply for an apportionment claim, because in certain states, it's considered a separate stream of revenue. I just had a case where I had to go back and get almost $100,000 for a veteran where the ex had applied for an apportionment claim, it had been granted, and they were paying all their support obligations, which I actually won that case. But without being able to show that there is an adequate supply of money being given to the custodial parent, it's very difficult. And then it's left up to the judgment of someone making that decision. And the VA has stated that an apportionment claim should consist of 20% to 50% of the total amount of VA disability. The state does 25%. I wouldn't want to go in and argue when I could get 25% in a state court versus going and losing half later. That's a really hard thing for me to try and manage because it's very, very subjective. The supremacy clause that Mr. Tucker cited does state that federal law supersedes state law, but it also is very clear that it doesn't involve election processes, divorce proceedings, things like that, because those are considered the purview of the state. And the VA honestly does not want to be involved in litigating a divorce or determining a support amount. That's not their role. They're not there to do that. And they're not a judicial body, so they can't really make a determination like that legally. As I stated in my written testimony, there are no other states that have a law like this. And I've been working on apportionment claims, as I stated, on both sides. So I will close my testimony. I did submit written testimony with more information, but I would like to open up to questions if anybody has any.
Thank you. Are there any questions for Ms. Ryan? Seeing none, thank you very much for your testimony.
Thank you.
Okay, so that's all I have on my list for testimony, and I see no hands raised. So I will close the public hearing on HB 317. Then I will give the clerk a few minutes and we will open the executive session on HB 188. So I'll wait for the clerk to get her things together. Madam Clerk, just let me know when you're ready. Okay, so I'm going to open the executive session on House Bill 188. Representative Belanger, do you have a motion?
I do, Madam Chair. I make a motion that we OTP House Bill 188.
Seconded by Representative DeSimone. Representative Long, would you like to introduce an amendment or anything?
I would. Thank you, Madam Chair. I'd like to introduce amendment. Oh, geez. Sorry, let me. I'd like to introduce amendment 2021-0387H.
Would you like to speak to your amendment?
I would. Thank you, Madam Chair. So the amendment, the notice goes out to the lawyers. It clarifies when a notice will go out. Instead of waiting for determining indigent juvenile, the notice goes out to the lawyer immediately, and it qualifies that on the second line on lines 20 21 to 24. And it also allows that if the juvenile, it clearly states that if the juvenile is not found to be indigent, then they can back up and not appoint a lawyer. If they could pick their own lawyer. And then finally, it clarifies better what the courts will be seeking for payment. That it clarifies that it will not seek attorney payments. It'll be fees and restitution that the juvenile court decided to give towards the juvenile. Thank you, Madam Chair.
Thank you. Are there any questions for Representative Long? Is there any further discussion on his amendment? Seeing none, I'll ask the clerk to call the roll on the adoption of amendment, hold on, 2021-038-7H.
Representative DeSimone,
Yes.
Representative Yokella,
Yes.
Representative Lewicki,
Yes.
Representative Bellinger,
Yes.
Representative Marsh,
Yes.
Representative Litchfield,
Yes.
Representative Smith.
Yes.
I'm sorry. There was a little noise in the background. Representative Smith, please.
Yes.
Thank you. Representative Long,
Yes.
Representative Ali Sayah, yes. Representative Grossman,
Yes.
Representative LeVey,
Yes.
Representative Wazor, Representative Wazier. I'm sorry.
Yes. Sorry, I had an internet connection problem for a minute.
Representative Petrino,
Yes.
Representative Altshuler,
Yes.
Madam Chair, Representative Rice.
Yes.
The vote is 15-0.
15-0, the amendment is adopted, so the motion now is ought to pass as amended. Is there any further discussion?
Madam Chair,
Who's saying that?
Representative Yokella.
I'm sorry. Yes, Representative Yokella.
Thank you. Is it my understanding that this still seeks to change how the lawyers are paid from a set stipend to an hourly rate, essentially? And is that understanding still correct, even with after this amendment is adopted?
Representative Long?
Thank you, Madam Chair. The answer is yes. Yeah, the amendment doesn't change the flat fee to hourly.
Is there any further discussion?
And
Representative Yokella?
thank you. Did we get a FN on this?
Yes, it was sent to your email. We do not worry about the FN though. That's for finance to worry about. We strictly vote on the policy. Is there any other questions? Seeing none, I'll ask the clerk to call the roll. The motion is ought to pass as amended on House Bill 188.
Representative DeSimone,
Yes.
Representative Yokela,
No.
Representative Lewicki,
Yes.
Representative Belanger, sorry,
Yes.
Representative Marsh,
Yes.
Representative Litchfield,
Yes.
Representative Smith,
Sorry, yes.
Representative Long,
Yes.
Representative Ali Saya, yes. Representative Grossman,
Yes.
Representative LeVey,
Yes.
Representative Wazar,
Yes.
Representative Petrino,
Yes.
Representative Altschiller,
Yes.
Madam Chair, Representative Rice,
Yes.
(14 to 1).
Will there be a minority report? No? So Representative Belanger will write the majority report? Thank you. Okay, so I'm going to close the executive session on House Bill 188 and give the clerk a few minutes before we go to 254.
Thank you.
Pardon me, Representative Rice, this is Christina.
Yes.
Time to get, possibly to get those two bills, the reports today so that we can.
Yes, that's my plan.
Okay, perfect.
They're already going to send me, they're immediately going to send me the committee reports and we're going to get them over there.
Perfect. Thank you so much.
Madam Clerk, just let me know when you're ready.
Okay. Almost done. We can begin 254.
Yes.
Okay, I'm ready.
Okay, so I just want to address, because we had started this last week and then we had the thing where it just all went away. So I'm just going to have a start from the beginning again and then we'll, go on from there. So Representative DeSimone, did you have a motion?
Thank you, Madam Chair. I do. I make a motion of ought to pass.
Seconded by Representative Lewicki. Did you want to speak to your motion? Oh, wait a minute. I'm going to introduce an amendment. Okay, so I'm going to introduce Amendment 2021-0140H, which removed the care management entity from the bill. Does everybody have it? I'm sorry, I know last week was really confusing. And it also updated some of the offenses that kids could not be put in the Sununu Center 4, and it, what else did it do? Gosh. Oh, it changed we originally were going to have the detained, but we changed the date to 6 months out to give the courts and the Sununu Center time to accommodate this, and also the community organizations that will probably be serving a lot of these kids. Does anybody, Representative Long, did you have a question?
I didn't have a question. Did you get a second? I'll second it if you didn't get a second.
Oh, thank you. I don't think I did. Thank you. Is there any further discussion on this? Seeing none, I'll have the clerk call the roll on adopting Amendment 2021-014-0H.
Representative DeSimone,
Yes.
Representative Yokella,
Yes.
Representative Lewicki,
Yes.
Representative Belanger,
Yes.
Representative Marsh,
Yes.
Representative Litchfield,
Yes.
Representative Smith,
Yes.
Representative Long,
Yes.
Representative Ali Sayed, yes. Representative Grossman,
Yes.
Representative Levesque,
Yes.
that was a yes, yes, correct.
Yes.
Representative Wazar,
Yes.
Representative Petrino,
Yes.
Representative Altschiller,
Yes.
Madam Chair Rice, Representative Rice,
Yes.
15-0.
Christina, can this go on consent even though I'm requesting for it to go to finance?
I don't believe so, but I will double check for you.
Okay, I didn't think it could, but I just wanted to double check. Does anyone object to consent if it can go on consent? Representative Yokella?
Thank you. We still haven't voted on the actual bill. We just voted on the amendment, but
Oh
I
my
want
God,
to
you're
speak
so
to the bill.
right. Thank you. I'm
Thank you.
sorry.
And I believe that I would object to being on consent since it is a financial.
Yeah, I don't think it can, so that's why, but I wanted to verify it.
But as in reference to the underlying bill, now that we are talking about OTP as amended, I would like to thank Zoom for cutting us off last week. That made me have a lot of time to
Somebody needs to mute.
Thank you. I wanted to thank Zoom for cutting us off last week so that I had more time to look into this bill and look at all of the ramifications, and am now happy to support the bill. So I just wanted to shout out Zoom for making that happen. Thank you.
Okay, so now the motion is ought to pass as amended. Is there any further discussion? Seeing none, I'll ask the clerk to call the roll as soon as she's ready.
Madam Chair, who made the motion for OTPA?
Well, it continues with Representative DeSimone because we introduced the amendment, so it just changes that nobody has to make a new motion.
All right, thank you. Representative DeSimone,
Yes.
Representative Yokella,
Yes.
Representative Lewicki,
Yes.
Representative Belanger,
Yes.
Representative Marsh,
Yes.
Representative Litchfield,
Yes.
Representative Smith,
Yes.
Representative Long,
Yes.
Representative Ali Saya, yes. Representative Grossman,
Yes.
Representative LeVey,
Yes.
Representative Wazir,
Yes.
Representative Petrino,
Yes.
Representative Holtscheller,
Yes.
Representative, Madam Chair, Representative Rice.
Yes.
Thank you. That passes 15-0.
Thank you very much. Since we have the time, why don't we exec one more real quick, okay?
Madam Chair, I just wanted to let you know that I did verify that it cannot go on the consent calendar.
Great, thank you.
Okay.
We'll do House Bill 541 when the clerk is ready.
And, 254. One moment, please.
No problem.
My kitchen table isn't very big. I'm ready.
Okay, thank you. Representative Lewicki,
Madam Chair, I move in expedient to legislate on 541.
is that seconded?
Second.
Who seconded it, please?
Representative Belanger,
Thank you.
would you like to speak to your motion?
Yes, Madam Chair. I believe that this is an exercise in futility because if somebody chooses to pay a lawyer directly, we cannot possibly attribute those funds to someone, to a defendant.
Is there any further discussion? Okay, well, seeing none, I'll have the clerk call the roll.
Representative DeSimone,
Yes.
Representative Yokela,
Yes.
Representative Lewicki,
Yes.
Representative Belanger,
Yes.
Representative Marsh,
Yes.
Representative Litchfield,
Yes.
Representative Smith,
Yes.
Representative Long,
Yes.
Representative Ali Saya, yes. Representative Grossman,
Yes.
Representative LeVey,
Yes.
Representative Wazar,
Yes.
Wazir, I'm sorry. Representative Petrino,
Yes.
Representative Altshuler,
Yes.
Madam Chair, Representative Rice.
Yes.
It's 15-0.
Without objection, this can be placed on the consent calendar. Okay, so I'm going to close this executive session and we will all be back here at 1:15. Thanks so much, everybody. What a great morning. Thank you.
Thank you.
Let's check this puppy out. Oh my gosh, my legs feel
Yeah. So if you're in Zoom, down the bottom, it will say, it says participants. And currently we have 31 participants. And if you click on participants on the right hand, it will bring out panelists and attendees. And then you want just 1 minute or you want? I think the 1 minute is ample time, 1 minute left. I can't see it. There, up a little. There we go. Is that it? Yes. Okay. No. So when they have 1 minute left, then you want, can you do?
So Pat, just so you know, I'm going to do, because there's 22 people signed up, so I'm going to give them 5 minutes
Okay.
instead of the 2 like I had originally said when I thought it was going to be many more.
Okay, I'd see that Representative LSA is in the attendees side. Is that going to be an issue?
Yeah, why is she over there?
Yeah, she should be in the panelist.
We'll move
yeah.
her. Hold on. I think Christina can bring her over when she comes on. But
Okay, we got her.
oh, thank you so much.
Oh my God. Hi, guys.
Hi, there you are.
Oh my God. I was following the instructions and I could hear you guys, but I couldn't get in. I was like, oh my God.
Happy you're in now.
Thank you so much. I don't know how. It's magic. Thank you. Kim, I'm sorry, Representative Rice. I'm very sorry.
Yes.
You'll be so proud all of your paperwork is in.
I never doubted it for a minute.
Okay, thank you.
Look what I got during lunch. Oh, you guys were not up close. You can't see me. Listen. My gavel.
Oh, cool beans. You needed it earlier.
I know, right? Really, again, you guys, though, this morning went so well. I'm just so grateful. Thanks to everyone.
You are welcome.
Okay, so good afternoon, everyone. Welcome back. I hope everyone had a great lunch. So we're gonna do the, we're gonna continue the public hearing on HB 68 that we had started last week. We had 22 people have signed up to testify, so I'm going to limit testimony to 5 minutes. And when you have 1 minute left, Representative DeSimone will hold up a sign so that you know that, so that the person testifying knows that they have 1 minute left. I would ask people who want to testify to try to touch on things that we haven't heard before and not echo the testimony before them, so that we get new information every time. Okay, and you know, I'm sorry I have to do this, but we have a lot of work to do and some members have to leave by a certain time today. So we're gonna start with Brandy Brown. Would you please state who you are, where you're from, who you are representing, and whether or not you have written testimony?
Yes, thank you. Brandy Brown, I'm a licensed clinical social worker. I'm speaking for myself, and I did email written testimony to the committee last night.
And where are you from?
I'm from Maine.
Thank you. Go ahead. But you have 5 minutes.
Thank you. Thank you. I'd like to express strong opposition to House Bill 68, an act relative to the definition of child abuse. This dangerous and misguided legislation targets an already vulnerable group of New Hampshire youth and denies them access to standard necessary medical care. As a program manager and clinical mental health provider for a large pediatric gender program in Northern New England, I work with many New Hampshire children experiencing gender dysphoria. I am also the current board president for the National Association of Social Workers, Maine chapter. As a social worker, following the NASW Code of Ethics, this legislation would make it impossible for me to meet my ethical obligations to the children I serve without violating New Hampshire law. Transgender children have the same needs as any other children, but they are unique because they're likely to experience a condition known as gender dysphoria, which manifests as clinical distress caused by the incongruence between their natal sex and their gender identity. This is a diagnosis outlined by the DSM-5, that's the Diagnostic and Statistical Manual of Mental Disorders, 5th edition, published by the American Psychiatric Association in 2011. An important clinical characteristic of gender dysphoria is that clinically significant distress must be persistent, greater than 6 months duration, and lead to impairment in multiple domains. Transgender children and adolescents need access to high-quality, evidence-based care for treatment of gender dysphoria. Social transition, and in many cases medical transition, is indicated to relieve symptoms of gender dysphoria. By transition, I'm referring to the process of a young person outwardly living as the gender that they identify. Treatment may include any combination of the following: talk therapy, family therapy, support groups, social transition, puberty blocking or suppressing medication, gender affirming hormones of testosterone and estrogen, and sometimes surgery. Please note there's no medical treatment option for young children who have not yet reached puberty. Best practice guidelines, including the standards of care published by the World Professional Association for Transgender Health, referred to as WPATH, and clinical practice guidelines published by the Endocrine Society, highlight the importance of providing medical treatment for youth within a multidisciplinary treatment trained setting. These are the prevailing practice guides in the US, and that is why most major pediatric gender programs have been established by leading children's hospitals. Treatment teams include mental health and medical specialists who have undergone additional training in this area. Treatment decisions are collaboratively made with the child, parents and guardians, mental health, and medical provider together. Medical treatment is only discussed if it is considered medically necessary after a mental health evaluation has been completed. In my practice, I often schedule additional appointments to ensure that all of those involved with the decision are comfortable with and fully understand treatment before moving forward. I consult regularly with clinical ethics and other pediatric teams across the country. This bill is unconscionable because it puts up a barrier between parents and their ability to access medically necessary healthcare for their children. Parents would have to choose between watching their child languish, knowing that in neighboring states they could receive appropriate medical treatments and compliance with New Hampshire law. In my experience, parents seeking healthcare for their children will go through great lengths to advocate that their children have access to high quality, effective, evidence-based medicine. I urge you not to silence these families and limit their options as they seek support for their children. Without access to quality medical care, gender dysphoria can result in terrible outcomes for children up to and including suicide. Any decision for a child or adolescent to stop medical treatment, especially one with such a significant impact on mental health and quality of life, should be done under the supervision of a qualified medical provider with support of a mental health provider. In the past year, we have experienced challenges related to medication access due to supply shortages related to the pandemic. The patients who are anticipating treatment delays displayed considerable anxiety around the possibility of delay and required an increased level of mental health support. To my knowledge, there's no evidence-based practice guide around abruptly withholding treatment. However, I would anticipate significant mental health decompensation for patients who are abruptly to lose access to treatment. Transgender children and adolescents need access.
Your time is up. Can you wrap it up very quickly?
Thank you. Need access to specialized medical care. This bill is designed to prevent them and their families from accessing the care they need. I urge you to vote unanimously against the terrible legislation and send a message to New Hampshire families that this committee will not consider legislation that forces families to risk everything to provide the health care needs for their children. Thank you.
Thank you very much for your testimony. Are there any questions for Ms. Brown? Seeing none, thank you very much.
Thank you.
Up next is Representative Amanda Toll.
Thank you.
Please state who you are, where you're from, and who you're representing, and whether or not you have written testimony. And please keep in mind you have 5 minutes.
Dear, hello, Honorable Chair and Children and Family Law Committee members. My name is Amanda Elizabeth Toll, and I represent Keene at large, and I'm going to be giving spoken testimony today. I strongly oppose HB 68. This bill attempts to add sexual reassignment to the definition of an abused child. This bill has quite literally nothing to do with protecting children from abuse. To the contrary, not accepting our children for who they are and forcing them to be something they are not is abusive. It can lead to catastrophic outcomes for transgender youth. I got elected on an intersectional feminist platform that included GLBTQ rights, bodily autonomy, domestic and sexual violence prevention, and child advocacy. I believe that the vast majority of Granite Staters, even Republican ones who may disagree with me about things like the size of government, support GLBTQ+ rights and public policy aligned with child advocacy. This piece of legislation is really just an anti-GLBTQ and anti-youth rights bill in disguise, pretending to be something to help children when it's really discriminatory and hurtful. This bill has the potential to cause irreparable harm to trans and gender nonconforming children. The American Academy of Pediatrics urges support and care of transgender and gender diverse children and adolescents. Jason Rafferty, MD, and the lead author of the American Academy of Pediatrics statement says, "We know that family and community support are essential for any child's healthy development, and children who are gender diverse are no different." He goes on to write, "What is most important is for a parent to listen, respect, and support their children's self-expressed identity." The statement goes on and highlights that transgender and gender diverse youth have higher rates of depression, anxiety, eating disorder, and substance use, self-harm, and suicide. However, children who are supported by their parents and family are more likely to experience physical and mental health. The AAP recommends taking a gender-affirming, non-judgmental approach that helps children feel safe in a society that too often marginalizes or stigmatizes those seen as different. The AAP emphasizes the gender-affirming model strengthens family resiliency and takes the emphasis off heightened concerns over gender while allowing children the freedom to focus on academics, relationship building, and other typical developmental tasks. Our job as legislators is to protect Granite State kids, no matter their identity. This bill does the opposite. Sadly, this bill showcases the prejudices of fellow lawmakers and in doing so harms a vulnerable population. Thank you for hearing my testimony. I am going to defer questions to the families directly harmed by this bill and the healthcare professionals who serve them. Thank you.
Thank you very much for your testimony. And you were deferring questions, correct?
Correct. Thank you.
Okay, thanks. So up next is Jonah Davis. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony. And please remember you have 5 minutes.
Hi, my name is Jonna Davis. I'm from Guilford, New Hampshire, and representing myself and my child. I just wanted to say that I have 3 children, 3 adult children. 2 of them were born female. My oldest 2 were incredibly happy growing up, and there were never any questions to their identities. My youngest child, Julian, associates as a male. Throughout his life, Julian fought his femininity. From wearing girl clothes and playing with girl toys, it was obvious. We just didn't see it. I'm sure his teachers saw it, and yet it went unnoticed. He climbed trees, searched for bugs, played with Ninja Turtles, and all throughout his childhood. He never invited girls to his birthday parties. His father and I passed him off as a tomboy. We didn't know anything else. I wish we knew then what we know now. By middle school and on many occasions, I would come home from work and he would be crying in his bedroom. I remind you that we raised two girl children. We knew what normal was at this age. This was not normal. Sometimes he would allow me to console him, but most times I would just sit on the floor at the end of his bed and wait for him to settle down to offer my shoulder. He just could not describe what was bothering him. I could only sit and watch him battle with the inner demons. To say that middle school was unpleasant for him is an understatement. Relationships were difficult. His attempts at dating were forced. He was picked on a regular basis for being different than everybody else. At 15, he was convinced that he was gay. Great, I thought. I finally had an answer. That he could have been worse things like pregnant. This revelation helped somewhat, but it never helped the pain entirely. He managed to find an accepting group of friends and had wonderful teachers who helped him through, and somehow he managed to make it through high school and graduate. But looking back now, I see that he was never happy. As a freshman in college, he decided to seek therapy. And last year, when he told me that he had concluded, and please notice that I use the word concluded, not decided, that he associates as male, I was not really surprised. This year, I have supported my child, my son, in his journey. As a parent, we only want our child to be happy. Watching him as he transitions into the person he was always meant to be has not always been easy. It's hard to understand, but I've never seen him happier. The transition has given him confidence that he has never had. He looks into the mirror and he likes himself for the first time ever. Forcing children to conform to our norms is not going to help a transgender child. Suppressing their identity does not make it go away. Puberty is hard enough on a child without the inner person fighting with the outward person's appearance. I know, I have witnessed this personally. What we didn't know is that we could have helped. Every parent should stop and think about what if it happens to them. I did not just decide I wanted to mix it up a little and have a transgender child. My child did not just decide that he could use a good challenge and pretend to be male so that he could get beat up in a bathroom. All the signs were there from early childhood, and we had been, if we had been better informed, if we had been educated, if we had known that we could simply and safely put off puberty and perhaps spare him the pain, depression, anger, and thoughts of taking his life, the confusion he was experiencing while his outward appearance was battling fiercely with his inner person. Hold on, I lost it. Not to mention the expense of the reconstructive surgery that he finally look like the person on the outside that he's been all along on the inside, which is not all covered by medical insurance, I might add. There is no doubt we would have sent him to therapy and put him on puberty blockers by middle school. Please vote no to this horrible legislation. Thank you.
Thank you so much for your testimony. Did you say you had written testimony?
I have written it down. I did not send it. I can send it to you.
Okay, that would be really helpful if you could.
Thank you.
Are there any questions? Okay, seeing none. Thank you very much.
Thank you.
Up next is Chris Urchel. I hope I said that right. If not, I apologize. Please state who you are, where you're from, and who you're representing, and whether or not you have written testimony. And please keep in mind you have 5 minutes.
Hi. Thank you so much, Chairperson Rice and members of the committee. My name's Chris Urchel, and I'm a New Hampshire licensed attorney, and I work for GLBTQ Legal Advocates and Defenders, GLAAD. We're based in Boston, but we are the go-to legal services provider for LGBTQ rights issues across New England. I did submit written testimony, and I believe you all have it. And I am going to take to heart the message that you don't want me to repeat things that other people have already covered. And so, yeah, you've already heard from medical professionals talking about the medically necessary care that transgender young people need. You've heard about what gender dysphoria is. You've heard about the lived experience of transgender youth in New Hampshire. So I am going to skip right ahead to focusing on the law and specifically the development of non-discrimination law in New Hampshire. I know you all are well aware that in 2018, HB 1319 changed the landscape of transgender rights in New Hampshire. And finally, after many years of effort by advocates and activists, this body was instrumental in passing HB 1319 and ensured non-discrimination protection for all transgender people in all areas of public life in New Hampshire. And then beyond that, the following year in 2019, a new statute was passed, went into effect that protected young people in schools, and based on gender identity, based on sexual orientation, based on sex, religion, race, all of the protected classifications that protect people from discrimination and other aspects of public life. So after all of that effort, there was still more work to do, and there still is more work to do. And I want to highlight a couple of other important advancements in terms of the lived experience of transgender people in New Hampshire. One important bill that was passed ensured protection for transgender people when it comes to accessing healthcare. And in fact, just last year, the Division of Insurance issued a bulletin further explaining why those protections are necessary and how they operate to ensure that transgender people are entitled to be free from discrimination in accessing medical care. And so I'm highlighting that because it's in direct contradiction to what this bill proposes to do. You can't, on one hand, say that transgender people in New Hampshire should be free from discrimination in accessing healthcare, and then on the other hand, say that granting the right to access healthcare is child abuse. And then another important piece of legislation that passed a couple years ago that became law in New Hampshire is the bill that prohibited conversion therapy. So the bill that prohibited conversion therapy made it unlawful to try to force a person to conform to their natal sex instead of living in their true gender identity. That law was a groundbreaking and important move forward in New Hampshire. And I just want to clarify that that is completely at odds with what this bill is trying to do. HB 68 is trying to force young people to live in their natal sex and not live consistent with their gender identity. And it sends the opposite message of what all of the legislative progress that we've made over the years is. And I do want to emphasize that that young people in New Hampshire are entitled to the support of not just the communities that surround them every day, but the legislature and every other body that represents the state. Just like everyone else, they're entitled to live free from this kind of attack on their well-being. And I'm happy to take any questions.
Thank you so much. Are there any questions? Seeing none. Oh, I'm sorry, hold on. Representative Long has a question.
Thank you, Madam Chair. Just clarity on, so the House Bill 1319, was that 2020? That you suggest is in conflict with this one?
No. HB 1319 passed in 2018 and went into effect, I believe, on January 1st of 2019.
Okay, that's great. Thank you.
You're welcome.
Are there any further questions? Seeing none, thank you so much for that testimony. That was helpful.
You're welcome.
Up next is Kelly Moore. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony. And please remember to keep it to 5 minutes.
Hi, my name is Kelly Moore. I'd like to thank you for taking the time to listen to me today. I put in written testimony when it was scheduled prior this bill, and then it was pushed forward, so I can resubmit that. I'm representing myself. So I'm a mom of a 14-year-old boy. His name is Devin, and he's really good in school. He likes to play golf, and he's a really great tennis player. He goes snowboarding on the weekends, and he's really close with his cousins and his family. We're hoping he gets into Derryfield next year. And he's just like an all-around great, very kind, non-judgmental kid. And he also happens to be transgender. That's just a part of him. It does not define who he is. We kind of knew when he was very young that he was a tomboy, is what we thought, because I was not educated about being transgender. And I think that that's a common issue in today's society, is people just need to be educated about this, that it's not something scary or crazy. It just is. It's a medical situation where my son was born with female body parts. You know, he wore baseball hats, he played football. He was just a tomboy. And he went into counseling because he started having some just, emotional struggles when he was 8. I mean, we were in 3rd grade. That's young for a kid. And he told me he wanted, so he had put on his Christmas list to Santa that he wanted to be a boy, and he prayed to God to be a boy. So that should have been like, glaring signs at that time. but I still was not sure. When we were seeing a therapist, they suggested that I let him explore this. And so I did. I let him get his hair cut, and he started going by male pronouns. The school he was in at the time would not work with us. He had a very feminine name when he was born, and they would not use his male name. So I went to court and I changed his name, which was a relatively easy process, and something that I knew that I could change back if this was just a phase. I do research for work, so I did a lot of research on this topic. And of course, this was my child. This is my life. This is my son. He's my life. And I just want him to be happy and healthy. So we started seeing an endocrinologist and kept seeing a therapist. And the next step was really puberty blockers. And I was, I needed to do a lot of research on that because that's medical. But puberty blockers are completely reversible. So even if he took those till he was 13, and then it was just a phase, he could go off of them and go through puberty as a girl. So that gave a good amount of time for him and I to really know that this was something real that he wanted. This was not an easy time for him. He didn't choose this path. He got teased. I pulled him out of school. Like just one day, he just never went back because of the way he was treated by teachers and kids. Just so wrong. It's just not, it's like not okay. Oh, sorry, 1 minute. So anyway, he has transitioned. He is 14. He knows he's a boy. He is not having any kind of surgeries or anything like that. He's happy, he's healthy, he is a good member of society, he's kind to people, he's non-judgmental. And if he didn't transition, I don't think I'd have a child. So, I think that this bill shocks me, but I strongly oppose this bill because I think I'm a good mother raising an incredible child, and being transgender is just a thing. It's you're transgender. So thank you for your time.
Thank you so much. Are there any questions? Representative Grossman.
Thank you, Chairwoman Rice, for taking my question. And thank you, Kelly, for coming to speak with us and share your story. I'm just curious, are there supports and services? Are there parent groups in the state? Like, what supports are there for parents right now? Because I'm a parent of a child that has a disability, and I know that support groups have been critical. So I'm just curious if in New Hampshire we have that.
Right. So when he transitioned at 8 or 9, that's actually very early, especially for these days. People have just started learning what being transgender is about, and it's become more public. There were very few. We were kind of a nationwide connection of people that got together. Like a few times a year, there's a camp or 2 camps. Now I have found, so my son went stealth, which means that he didn't let anyone in his life know that he was transgender because he felt it was dangerous and he didn't want to get bullied. So he is private. So we did not go to support groups for a while. Pre-COVID, a lot of support groups popped up. A lot of support groups for his age group, teenagers, and they're kind of all encompassing with the LGBTQ community. There's events, there's online events, it's really nice to see so much more support. So it is available.
Great, thank you. Thanks for sharing that.
Are there any further questions? Seeing none, thank you so much.
Thank you.
Up next is Abby Maxwell. Please state who you are, where you're from, and who you're representing, and whether or not you have written testimony, and you have 5 minutes.
Hello. Thank you for hearing my testimony in opposition to HB 68. My name is Abby Maxwell. I'm from Concord, and I did not yet submit my testimony in writing. I'm the parent of an 8-year-old girl. Recently, she filled out a Valentine's worksheet for school, and in it, I learned that she loves that she can go in the woods from her backyard, swim, and play video games, that she loves that she is brave, happy, and nice, and that she loves that she has pets, woods in her backyard, and lots of friends. I believe that is a good snapshot of my daughter, whose medical care and parents this bill attempts to criminalize. That's because my daughter also happens to be transgender, which in her case means she was assigned male at birth, but is female. She first began to tell us of her gender when she was 3 years old. My husband and I did not know what to make of it. And frankly, we suppressed it as much as possible. Yet as the years went on, she became increasingly insistent. And when she was 6, she told us that she did not want to exist anymore if she had to continue to be a boy. We sought medical advice, and eventually we were referred to the Boston Children's Hospital. There we learned about what it means to be transgender and the best practices of gender-affirming care to help my daughter have a happy, healthy life. Finally, after multiple appointments and lots of research, we allowed her to change her name and pronoun and to dress and live as the girl she'd spent years telling us she was. The change was remarkable. It was like a light came on inside of her overnight. All who knew her noticed the shift instantly. I know what harms my daughter. It is that she lives in a culture in which she came home from 2nd grade to tell me that she understood that most people in the world hate transgender people like her. It is that her parents have to spend so much time and energy fighting for her right to exist. It is bills like this which not only threaten her actual life, but also the health of our communities. Already, we have moved from the small New Hampshire town where my family has been for generations because of the discrimination, bullying, and harassment my daughter faced. I know that is not what we want for our state. We do not want to be a place that pushes difference out. Yet this bill would tell our trans youth that they will not be safe here, that they do not belong here, and in fact, that we want them gone so badly that we are willing to criminalize their life-saving medical care. That is not the message our state should ever send its residents. That is not how we build safe communities in which all our children can thrive. In the past few years, our lawmakers have made great strides in making our state more inclusive. I urge you to oppose this bill and continue the work of building a New Hampshire that is safe for all its children. Thank you.
Thank you very much. Are there any questions? Seeing none, thank you so much. Up next is Jennifer Smith. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony. And please remember you have 5 minutes. Jennifer Smith. Jennifer Smith. All right, we'll have to come back. So we have Adam Henney. please, do you have him? Sophia Biondolillo. Oh, I know, I just killed that name. I'm so sorry. Charlie McCall.
Hi, this is Sophia. Can you hear me?
Okay, yes. Could you please state who you are, where you're from, and who you are representing, and whether or not you have written testimony? And please remember you have 5 minutes.
All right. Thank you, Madam Chair and members of the committee for taking my testimony today. My name is Sophia Biondolillo. I'm 14. I live in Manchester. I have written testimony and I will email it to you guys after the hearing. And I'm speaking today on behalf of the New Hampshire High School Democrats in opposition to HB 68. I am opposed to this bill because if it were enacted, it would have devastating effects on the mental and physical well-being of thousands of New Hampshire citizens and deny them access to health care that is absolutely necessary for their basic health. There are a number of reasons that this bill is not viable, but first and foremost is the wording. Nowhere in this bill or in the original legislation is the word subject defined, so it could be one of two things. Either this is in reference to a parent forcing their child to transition, or it is simply just a ban on transitioning for minors. I think it's highly unlikely that this bill is strictly intended to prevent parents from forcing their children to medically transition, because we all acknowledge that that would be ridiculous. Forced transition is not happening in this state or anywhere in this country, and it would be extremely difficult if ever attempted. I think what's much more likely is that this bill is, explicitly or not, intended solely to prevent minors from transitioning and accessing the healthcare they need. So let's assume that subject could apply to situations where a child willingly transitions. In that scenario, I would like to address several things, as I'm sure that several people will testify today, to try and convince the committee that transitioning is dangerous when it is not. Firstly, some people claim that people who transition are motivated by mental illness. They might cite that transgender people are more at risk for certain conditions. However, this insinuates a relationship between being trans and having mental illness that does not exist. A more accurate way to represent this statistic would be that people who are trans are more likely to be harassed and traumatized due to their identity. In addition, there is a condition called gender dysphoria that many transgender people have, which is defined by the American Psychiatric Association as psychological distress that results from an incongruence between one's sex assigned at birth and one's gender identity. This experience can be crippling for many transgender people and can contribute to other aspects of their mental health, but it is also the reason why transitioning is so important for people with gender dysphoria. According to a study from 2018, people who have gender dysphoria are at higher risk for suicidal ideation and other mental health issues, as we've heard. Transitioning is one of the only ways this type of dysphoria can be treated and relieved. So not only is being transgender not a result of mental illness, but in fact, transitioning significantly improves mental health for trans people with gender dysphoria. Some also say that transgender people may regret transitioning. However, that data is largely outdated. In a study in 2005 that sampled 325 people, only 2 expressed any regrets after transitioning. This is a minute percentage and in no way represents any significant amount of people, especially when you consider that almost 5,000 transgender people are estimated to live in New Hampshire. The researchers also stated that after treatment, the group was no longer gender dysphoric, and that the vast majority functioned quite well psychologically and socially. Detransitioning is not a major issue in New Hampshire's communities or anywhere else, and trying to use that to justify a dangerous and hateful bill is not only wrong, but also wholly lacking in any real logical basis. In conclusion, what is important to recognize is that transitioning as a transgender person is not a result of mental illness or a trend or a phase, but it is something that is necessary for many transgender people and those who experience gender dysphoria. Preventing transgender people from accessing the help they need directly harms them, and if this bill were to be abused, it would have exactly that effect. So in conclusion, I urge the committee to do what is necessary to protect transgender people in the state, join the NHHSD, and oppose HB 68.
Thank you very much. Are there any questions? Seeing none, thank you very much for your testimony. So up next is Amy Manzelli. Please state who you are, where you're from, and who you are representing, and whether or not you have submitted written testimony. And please remember you have 5 minutes.
Thank you. Good afternoon, Honorable Vice Chair DeSimone. Can you hear me?
Yes.
Thank you. My name is Amy Manzelli. I'm from 418 Ross Road in Pembroke, New Hampshire. I submitted my and my husband's letter dated February 3rd over email, so hopefully you have that in your record. I'm here today with my husband, Chad Trammell, and with our 11-year-old transgender daughter, Iris.
Hi.
We'd like to request respectfully that you vote ITL on House Bill 68. We wanted to share with you a bit of our daughter's story, and you'll hear some commonalities from the other stories you've heard. While Iris was assigned male gender at birth, it is clear to us now that our daughter has always been a girl. Beginning at age 3, every year she said she wanted Santa Claus to turn her into a girl. Eventually, when she was 6, she wanted her outward identity to match her inner identity. And I went into the details in my letter of how she expressed that to us in very child-appropriate ways. She needed to wear only girls' clothes. She needed to use the female pronoun. She needed a girl's name. In a matter of a few months, her coming out was complete, including our family having established a wonderful relationship with the great team at Boston Children's Hospital. Our daughter sees an entire team of health professionals there who collaborate with similar experts worldwide, including a medical doctor, a nurse practitioner, and a psychologist. Our daughter's capable team adhere to the gold standard in medical treatment of gender diverse patients. That is, to perform a comprehensive psychological and medical assessment to create an individualized treatment plan. Our daughter's providers know that untreated gender dysphoria would put her at much greater risk of suicide and other grave emotional challenges. HB 68 would put us as parents in a position of becoming criminals under New Hampshire law if we follow that individualized treatment plan created by our daughter's medical team. It would put our daughter at risk of grave harm. Other children's families have the personal freedom to decide what medical treatment is appropriate for their children. Our family would have that taken away from us if HB 68 became law. It's been almost 4 years since Iris came out, and her identifying as a girl remains consistent and persistent. She's gone through the legal processes to change her gender marker to female and to change her name to a traditional name for a girl. Iris being a girl is like the color of her skin or the height she will be when she grows up. It is an inescapable, inherent characteristic. We are so proud to live in the Granite State, where our daughter's rights as a transgender girl have been recognized and protected. Please do not erode this progress. Our daughter has the same rights as any other girl. As a licensed attorney, I know that the legal community agrees with this. The medical community agrees. I hope this esteemed committee will also agree by ITLing HB 68. And Iris would like to say a brief word to the committee.
Hi, my name is Iris Trammell. Please don't make my parents criminals for giving me the medical treatment that I need. Please vote no. Thanks.
Thank you, members of the committee. We would welcome any questions.
Thank you. Are there any questions? Seeing none, thank you very much.
Thank you.
Up next is Jeannie Haruska. Please state who you are, where you're from, and who you're representing, and whether or not you have written testimony. And please remember you have 5 minutes.
Thank you, Madam Chair and members of the committee. My name is Jeannie Haruska. I'm from Concord, and
I'm sorry, Ms. Haruska, can you hold on 1 minute, please? I'm sorry. Representative Marsh. Representative Marsh. Representative Marsh. I'll take care of this. I am very sorry for the interruption, Representative Haruska. Representative Jeannie Haruska, please continue.
No worries. So I'm the political director and will be representing the American Civil Liberties Union of New Hampshire. I appreciate the opportunity to testify today in opposition to HB 68. There's been some incredible testimony given already, and so I'm going to focus my oral testimony on our legal concerns with this bill, and I've submitted longer written testimony to the committee. I want to underscore that passage of this bill would result in New Hampshire falling out of compliance with state and federal law, which could open the state to legal action by those families prevented from accessing medically necessary care. Federal courts have held that discrimination against transgender individuals is impermissible sex discrimination under the US Constitution and federal laws prohibiting discrimination on the basis of sex. This includes Title VII and Section 1557 of the Affordable Care Act. Moreover, discrimination against transgender individuals is also impermissible sex discrimination under our comparable anti-discrimination state laws. Where a law singles out people based on the fact that they have a gender identity that does not match the sex assigned to them at birth, it necessarily discriminates on the basis of sex and trans status. As the US Supreme Court stated just last year, quote, "It is impossible to discriminate against a person for being transgender without discriminating against that individual based on sex." For example, a bill that permits medical treatment, for example, hormone therapy, when medically necessary for a non-transgender minor, but that would criminalize parents for supporting the same procedure for a transgender minor for whom it is also medically necessary treatment for gender dysphoria, discriminates based on sex, gender identity, transgender status, and sex stereotyping. Put simply, this bill would result in discrimination. It would deny families the ability to care for transgender minors and ultimately lead to devastating health outcomes for vulnerable young people. The bill has no sound basis in science or medicine and would open the state of New Hampshire to costly and protracted legal challenges. For these reasons, I respectfully urge the members of this committee to vote ITL on HB 68, and I'd be happy to answer questions.
Thank you very much. Are there any questions? Seeing none, thank you very much for your testimony.
Thank you.
Up next is Amber Latour. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony. And please remember you have 5 minutes.
Good afternoon, members of the Children and Family Law Committee. My name is Amber Latour, and I live in Guilford, New Hampshire. I'm here as a private citizen representing myself. I have sent in testimony. I'm here to oppose HB 68 relative to the definition of child abuse. I've thought the previous testimony has been very powerful, especially from the parents of trans children. I have a little bit of a different perspective as I am a mom of an 8-year-old cisgender daughter. But at any point she shows that she identifies as a trans child, it would be a long process with many healthcare providers involved. Gender affirming treatments are not taken lightly, and they're under the care of a trained doctor. I have concerns with this bill, as any parent should, because it inserts the government into the role of parents and doctors and prohibits them from making informed decisions for the children whose care is entrusted to them. We've heard study after study has shown that affirming trans kids and following the affirming model has been recommended by nearly every major medical association. On a personal level, I have witnessed one of my daughter's friends come out as trans. And I've seen how much affirming her gender has impacted her behavior in a positive way. She is much happier, she smiles more, and it's so easy to see her confidence has improved. It's like she is a different child. She has caring and loving parents, and this is not abuse. For a parent of a trans kid, this bill can do harm to a child's future and can contribute to more suicides. But all of us parents should be concerned about a bill like this. Medical treatments should be private matter between children, their parents, and trained doctors. I urge you to oppose this bill and keep the government out of our doctor's offices. I want to thank you to the committee for allowing me to express my concerns about this bill. Thank you.
Thank you so much. Are there any questions? I see none. Thanks again. Up next is Kim Peasley. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony. And remember, you have 5 minutes.
Good afternoon. This is Kim Peasley. I am from Concord, New Hampshire. I'm an attorney in the area. I work and live here. I am representing myself and my transgender son. I did submit written testimony on the 3rd. If you need me to resubmit it, I'm happy to do so. I won't need 5 minutes, and I appreciate everyone who's spoken before me, but just wanted to add my 2 cents. Madam Chairman and the rest of the committee, thank you so much for your time today. I'm testifying today in opposition to HB 68, introduced by Representative Dave Testerman of Merrimack. His bill, as we all know, seeks to add sexual harassment to the sexual reassignment to the definition of an abused child. As a legislator in New Hampshire, one must take an oath, which states in part, I will faithfully and impartially discharge and perform all the duties incumbent on me as a state representative, according to the best of my abilities. It is also to be understood that prior to proposing any law to abridge citizens' rights, a modicum of research on the relevant subject matter should be a requirement. A brief Google search provided me with the following, that as far back as 2019, the American Medical Association approximated about 150,000 youth ages 13 to 17 in the US identify as transgender. That meaning those individuals whose gender identity and or expression is different from cultural expectations based on the sex they were assigned at birth. The AMA notes that every major medical association in the US recognizes the medical necessity of transition-related care for improving the physical and mental health of transgender people, where medically necessary services that affirm gender or treat gender dysphoria may include, but are not limited to, mental health counseling, non-medical social transition, gender-affirming hormone therapy, and or gender-affirming surgeries. Furthermore, the AMA has found that gender-based discriminating affecting access to services
This bill suggests that the
such as HB 68 is a strong predictor of suicide risk among transgender persons. Here are teens. The AMA cited studies which show that suicide rates dropped from 30% pre-treatment to 8% post-treatment. HB 68 runs counter to the state's most precious tenet, to live free. I, for one, take these liberties very seriously. HB 68 seeks to marginalize a subset of our children and criminalize their medically necessary health care. To interfere with our children and their doctors, to interfere with parents' care for their children, is clearly an interference on our children's life, liberty, and privacy, just to name a few. On its face, this bill is born not only out of ignorance, but is a blatant attempt to dehumanize a group of individuals deemed different or less than by the bill's sponsor. Trans men are men. Trans women are women. They are citizens of our country and of our state, and just like me, we all deserve protection under the Constitution. New Hampshire children should be able to live free and not die due to withholding of medically necessary treatment by the New Hampshire legislature. I also believe strongly that accountability is needed for those who seek to dehumanize any group, whether through their use of language or their actions. My position is that HB 68 is repugnant to the rights and liberties contained in the New Hampshire State Constitution and must be deemed inexpedient to legislate. Thank you for your time.
Thank you so much. Are there any questions? Seeing none, thanks again.
Thank you.
Up next is Matthew Crone. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony. And please remember, you have 5 minutes.
My name is Matthew Crone. I'm from Auburn, New Hampshire. I'm just representing myself. I have emailed in written testimony. Most of what I have to say has already been said. I just felt it necessary to speak out on behalf of every parent and child who may have to work through such a potentially difficult process. As a parent, my job is to support, trust, and love my child. And this bill directly interferes with that relationship by making it a criminal act to help your child receive gender affirmative care. You've already heard that the American Academy of Pediatrics condemns bills like these about the long-term psychological and physical and emotional harm that can be caused by denying these gender affirmative therapies to children. The best way to help these transgender children is to ensure that it continues to be legal to provide them with medical care and to trust them when they tell us who they really are. This bill only serves to harm a group that is already at risk and should not be passed. Thank you.
Thank you very much. Are there any questions? Seeing none, thank you again. Up next is Rowan Quethan. I know I butchered that name. I'm so sorry. Please state who you are, where you're from, and who you're representing, and whether or not you have written testimony, and you have 5 minutes.
Thank you. So my name is Rowan Quetham. You actually got the pronunciation right. I'm from Manchester, New Hampshire, representing myself. I have not sent in written testimony, but I have written down my remarks and I can send them to you later today. We have already heard that HB 68 is not based in the latest medical science. We have already heard that it would deny life-saving care to an incredibly vulnerable population and contradict existing law. And we have heard very moving testimony from parents of transgender children as well as a transgender child. I worry that the motivation for this bill, since it is not based in science or pre-existing law, is instead based in the belief that it is bad or wrong to be transgender. So what I want to offer you briefly is direct testimony from a transgender person. I am a gay transgender man. I grew up in rural Iowa in the late 90s and 2000s, and I did not even know what it meant to be transgender until I was in college. Now that I have transitioned, I can say confidently that the choice to do so was the best decision I have ever made. It has opened up my life in ways that I never could have imagined when I was a child. I don't even know how to express this to folks who haven't lived through something like it. When I look in the mirror and see my face, when I talk to people and hear the way that my voice sounds, when I look at my body and see how much it has changed because of the healthcare that I have been able to access, I am grateful every single day beyond words. The fact that young transgender people are now able to access quality gender-affirming healthcare at a younger age than I did is amazing and wonderful and should be celebrated, not stifled, because it is a good thing to be trans. I am so proud to be trans. This bill is unscientific, prejudiced, and cruel, and I urge you to vote no. I'm happy to take any questions. Thank you.
Thank you. Are there any questions? Seeing none, thanks so much. And I'm glad I didn't kill your name.
Thank you.
Up next is Lisa Pantelli. Please state, do we have her? Hold on. Okay, Nazir Alec. How about Jordan Applewhite? Okay, so please state, Jordan, who you are, where you're from, and who you are representing, and whether or not you have written testimony. And please remember, you have 5 minutes.
Thank you so much. My name is Jordan Applewhite. I live in Sugar Hill and I'm representing myself. I did not yet submit written testimony to the committee. I'm here to speak in opposition to HB 68, a bill which effectively criminalizes the existence of transgender children. I am a transgender resident of New Hampshire. Trans people, including trans children, want to live their lives with the same dignity and respect that is afforded to all other citizens, not to be stymied by bigotry and used as divisive political props. I came out just before my 30th birthday. Transitioning that late in my life was extremely difficult and disruptive. I know young people who are discovering themselves at a much earlier age, and it fills my heart with love and joy that they will not face the same difficulties I faced. It is my duty as an LGBT elder to make sure they don't. When trans youth receive medical treatment, it's typically to delay the onset of puberty until they decide they want hormone replacement therapy, or HRT. HRT allows them to experience gender-affirming physical development as they grow into adulthood, rather than feeling like a stranger in their own body, a condition called dysphoria, which leads many to depression and suicide. Trans medical care saves lives. Puberty blockers are safe. HRT is safe. So let me be clear. Anyone supporting HB 68 should be ashamed of themselves. This bill does not have the safety of trans children at heart. In fact, the language of the bill displays an obsession with regulating children's genitals. Anyone who thinks this is okay should seek counseling for this unhealthy fixation. It does not belong in our state legislature. Let trans children live their lives in peace. Now, I volunteer at my local church. I'm married. I own property, pay taxes here. I run a small business that employs 12 people. There are countless trans people just like me living among you. And if this bill is advanced, we and our allies will remember who is responsible for that, and we will mobilize against them. Thank you for your time, and thank you so much to the parents of trans children who showed up here today.
Thank you for your testimony. Are there any questions? Seeing none, thank you. Okay, so up next will be Nancy Brennan. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony, and you have 5 minutes.
Good afternoon. I did send testimony along with a couple of articles for you to look at. My name is Nancy Brennan. I'm an old cis woman from Ware. I speak in opposition to HB 68. Like some of you on this panel, and like the bill's sponsor himself, when we were 6 or 16 or 26 even, we didn't know, or we didn't know we knew any transgender people. We may have read Life magazine and heard about Christine Jorgensen, the first famous transgender person, a World War II vet who transitioned in the early 1950s. But we were mostly ignorant about what it meant to be transgender. I dare say that unless we are transgender ourselves, or raising a transgender child, or we are a medical worker treating a transgender person or researching what it means to be transgender, we still don't really know. But we can listen to our friends who are living this experience. We can read comprehensive evidence-based research, and we can hopefully separate fact from fake information. Representative Testerman said helping transgender children be their authentic selves just makes no sense. I would ask him to do some in-depth research, talk to parents, healthcare workers, and the many courageous young people who have given testimony on this bill, and all of those who spoke in favor of passing the transgender non-discrimination bill a couple of years ago. I would ask that he listen to the testimony he missed last week and maybe today as well. We have come a long way in 70 years. We now know that gender identity is a complex combination of brain function, gene variants, hormone levels, and myriad other factors, and that most transgender children are aware of their gender at a very young age. Helping these children live as their authentic selves makes them much happier, much more stable, and even saves their lives. Treating transgender children is not child abuse. One expert has said that denying proper care to transgender children is akin to denying care for asthma or cancer. These are decisions to be made for the families of the child themselves, their doctors and medical team, not to be made by legislators. I urge you to vote ITL on this bill. Thank you.
Thank you very much. Are there any questions? Seeing none, thank you. Up next is Julian Davis. Please
Hello.
state who you are, where you're from, and who you are representing, and whether or not you have written testimony, and you have 5 minutes.
Sure. My name is Julian Davis. I'm a resident of Guilford, New Hampshire. I sent in written testimony just a few hours ago, and I'll be representing myself today. So I have many concerns about this bill, like everybody else who has come to speak today. Thankfully, most of the people who have come to speak were able to clarify some misconceptions about transitioning during childhood, as well as some of the legal issues around this bill. So I won't waste my time by reiterating those details. Instead, I want to talk about what it's like to live as a trans youth without access to the medical care that we have gathered to discuss today. So some of you may have connected the dots. My mom came on earlier to speak about my experience, but I think it's important to sort of hear about how it is to live as a trans person directly from trans people as well. So I'm a trans person, of course, and I came to that conclusion as a young adult, but I often think about what life could have been like if I had access to blockers and HRT at a younger age. It was incredibly uplifting to hear the testimony of trans youth who have had the opportunity to express themselves before adulthood. But for me, there is a bitterness to these sweet stories of self-discovery. I find myself mourning the boy I never got to be in thinking of the 20 years worth of photos and home videos that my family and friends have that I can't cherish because the person in those photos is not me. I think about all the times I posed for one of these pictures or tried on an outfit at a clothing store, expecting to see myself as the person I felt I was, only to become overcome with shock, disappointment, and dread upon looking at the photo or gazing in the mirror. I remembered all the times I listened for the call of my dead name during attendance in class and cringed at the fact that I knew I would have to say here in response. And yes, like many people who identify as trans, I am forever marked by the painful memories and thoughts and attempts at suicide. The truth of the matter is, when I was growing up, I existed in a vice grip of standards and expectations that I could never meet. From the day that I was born until the day I realized why I felt so out of place, so removed from the present at all times, I was imprisoned both by my physical body and the set of roles and characteristics arbitrarily assigned to me by a doctor who took one look at my infantile body and said, "It's a girl." I'm grateful to come as far as I have under those severe circumstances, and I can finally say that the person I am out here matches the me I am in my head. But I can't get those 20 years of memories back. And it pains me to think that our state legislature might take from the trans youth of today 2 whole decades of their lives as well. Of course, Representative Testerman, having never experienced dysphoria himself or fathered a transgender child, has no understanding of what this is like. I don't fault him for that. I do, however, fault him for being purposefully obstinate in the face of countless statistical figures and data points surrounding this topic, and for being unwilling to listen to the accounts of those of us who do have a personal stake in this game. This man quite literally left the first hearing just prior to the response forum, which raises a question in my mind and, I'm sure, in the minds of many of those of us who testified as well. Why did Representative Testerman leave during the hearing? Perhaps he knew his ideas would not hold steadfast in the face of opposition, or perhaps he did not want to hear a slew of personal anecdotes about the lives of various trans teens and parents of trans children, whom, I would like to add, he is supposed to represent as an official of the New Hampshire House of Representatives. Either way, the message that I and my fellow citizens of the state of New Hampshire seek to convey applies. Representative Testerman, not only are your assertions on the matter faulty, their implications are dangerous. I urge you all to vote against House Bill 68. Thank you.
Thank you very much. Are there any questions? Seeing none, thank you very much. Up next is Michelle St. John. Please state who you are, where you're from, and who you're representing, and whether or not you have written testimony, and you have 5 minutes.
Thank you, Madam Chair and members of the committee. My name is Michelle St. John. I reside in Hollis, New Hampshire, and I'm representing myself and my transgender child. Thank you for the opportunity to provide testimony today. I'm here as a parent a New Hampshire resident, and a former state representative, and I'm voicing my unequivocal opposition of HB 68. I'm really not sure how many members of the committee have close personal relationships with any transgender youth, but I do. I have personal relationships with many. I don't know how many committee members know what it means to identify as a transgender, as it is one of, if not the most, misunderstood and discriminated population in the world today. Imagine waking up every day and realizing you're living in a body that has nothing to do with how you think and who you are. There are children in New Hampshire, across our nation, and throughout the world who do every day. Being transgender is never an intentional choice. Children look to their parents, relatives, and other adults in their life for gender-affirming support. It is not child abuse for parents to seek out and explore the gender-affirming medical standard care available for transgender youth. It's a process that includes many medical and mental health evaluations prior to the onset of care. Denying your child the opportunity to hit the pause button prior to the onset of adolescence, menses, or other bodily changes that occur in puberty can cause further distress, anxiety, depression, self-harm, and even attempted suicide. The Human Rights Campaign, the Transgender Equality Foundation, the American Academy of Pediatrics, and the Endocrine Society all provide excellent background on what it means to be transgender, provide familial support, and medical recommendations and guidelines for transgender children and gender-affirming care. If passed, this bill would essentially constitute parents as child abusers if they seek out the medical support necessary for gender affirmation care. I just ask that the committee let that sink in for a moment. Loving parents supporting their child's well-being accused of child abuse. We are all human beings. This type of legislation is discrimination. And I'd like to add that Representative Testerman brought this bill before the committee last session. To this situation today and the one before, he was the sole sponsor of the bill. And in his introduction on February 3rd, he self-admitted he has no interactions with any transgender children or adults. His only expertise in leading to this bill is that he's a parent and a grandparent. He has no medical background. And with that, I'd like to close and say, please vote ITL on this bill. And I appreciate your time. Thank you.
Thank you very much. Good to hear from you. Are there any questions for the Honorable St. John? Seeing none, thank you so much. Okay, that concludes our testimony. And so I will, wait, somebody just raised their hand. Jenny M. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony, and you have 5 minutes.
Awesome. Thank you so much. You guys can hear me?
Yes, thank you.
Awesome. So I'm Jenny Manzelli. I'm from Pembroke, New Hampshire. I'm representing myself and a family relative. I emailed written testimony dated on February 3rd. I'm wholeheartedly, strongly opposing HB 68. You guys have heard it all. I'm so thrilled to hear that there are so many individuals opposing this House bill. I applaud and thank all those trans attendees today who spoke up. I loved what Nancy Brennan said. I'm not going to read my letter verbatim, but I'm just baffled at how people like Representative Dave Testerman can, I just don't understand how they could live with themselves knowing that if this bill were to be approved, you'd be putting the lives of transgenders on the line. It baffles me. Makes my blood boil to think that people would mess with my relative like this and all the other lives of transgenders out there. I just get it. It doesn't make sense. You guys have heard everything, but the parents of my trans relative, they're not criminals. They should not be criminals. They have done nothing but love their transgender daughter for who she is and how she is. They're doing all the right things. They're getting the medical advice that this relative of mine needs. We are in the live free or die. I love how someone else said that this shouldn't be live free, or literally die. I'm thrilled and proud that my relatives' rights thus far have been recognized and protected. But again, this House bill, it would put an end to the progress that has been made thus far. And I just can't imagine the negative impact and the grave danger that would result from this House bill being passed. Please do not stop their progress. There are wonderfully medically trained professionals that are overseeing the lives of these transgender youths. It's with my deepest hopes that this esteemed committee will agree by voting to inexpedient to legislate this House Bill 68. Thank you so much.
Thank you. Are there any questions? Seeing none, thank you very much. Our last person to testify today is Aaron Brewer. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony. And remember, you have 5 minutes.
Thank you. My name is Aaron Brewer, and I did submit written testimony. I'm from Logan, Utah, and I represent myself. And I know we've heard a few stories from people who are very against this bill, but I am here in support of it. And it's because I was a trans kid. I was so insistent and persistent and consistent in my demands that I was a boy that my teacher sent me to the school psychologist to be evaluated. The school psychologist admitted that yes, indeed, I wanted to be a boy, but thankfully she did not affirm me. Instead, she came up with a plan to help me manage my feelings of distress and resolve those dysphoric feelings. It took a while, but eventually I did learn to feel comfortable with myself. And I'm so grateful that she did not affirm me, because if she had, I never would have had the opportunity to explore the fact that those gender dysphoric feelings, that trans identity, was the direct result of a sexual assault that occurred. When I was assaulted, I decided I was not going to be a girl anymore. I hated the body that I believed had been assaulted and wanted to distance myself from it. I absolutely did not want to be a girl anymore. And I'm not the only one. I've talked to many, many detransitioners who've had the same story. They felt that their body had betrayed them and they wanted to run away from it. If we encourage children to transition, we basically discourage them from, we discourage them from getting the help that they need to understand those feelings of self-hatred and shame that are so common with such sexual assaults. She did not affirm the self-hatred that I had. She did not put me on puberty blockers that would have induced a developmental delay. Instead, she put me in a communication group and she got me support, which is what I really needed. It breaks my heart to imagine what my life would have been like if my school psychologist told me that I was inherently flawed and that the only way to fix myself was to damage my healthy body with puberty blockers, cross-sex hormones, and surgery. Doing so would have prevented me from getting the help that I needed to understand the trauma that I endured. It would have convinced me that my disassociating from my body was appropriate and the only way to manage the feelings I had of distress. And it would have prevented me from having the 3 beautiful children that I have today that have brought me so much joy. It is heartbreaking to me that vulnerable children with history of trauma like mine, children who are autistic, children who have internalized homophobia,
children who are acting in ways that are not supported by today's social standards of stereotypes are being subjected to experimental interventions that damage their healthy bodies, especially when we know that the vast majority of them will resolve their feelings of dysphoria if they are allowed to progress naturally through puberty. These are children who deserve our love and our compassion. They need skills to manage their difficult feelings, but they also deserve our protection. They need to hear the message loud and clear. No child is born in the wrong body. Thank you very much for hearing my testimony.
Thank you very much. Are there any questions? Seeing none, thank you. So people are starting to raise their hands now. We are going to take a 15-minute break because we've been at this for a while. We need to get up and walk around. I see 2 hands up. Those are the 2 that I will recognize when we get back, and then we are done. Okay, we had plenty of time to sign up to testify in advance, and we have other business we have to attend to today. So we'll be back in 15 minutes. Thank you.
You're so sweet. I just thought that was safe.
Okay, if everybody can start moseying back to their computers, we'll start up again in a couple of minutes. Look at everybody's already. Okay, welcome back, everybody. Like I said, we have two more people to hear from. The first is Marie Landrigan. Please state who you are, where you're from, and who you are representing, and whether or not you have written testimony, and you have 5 minutes. Marie, can you hear us? Marie Landrigan, can you hear us? All right, we'll come back to Marie Landrigan and we'll go to Annie Blanchette. Please state who you are, where you're from, who you are representing, and whether or not you have testimony, and you have 5 minutes.
Hi, my name is Annie Blanchette. I'm from Lowell, Massachusetts. I'm representing myself. I did send an email. I don't know if that's the same as testimony. I've never done this before, so I'm really nervous and confused. I am supporting this bill. Though I live in Massachusetts, I have a grandson that lives in New Hampshire who has been pushed on the path of the gender ideology, and that's what I call it because that's what I believe it is. I believe it is not an ideology. He was not even 7 years old when my daughter and her transgender spouse decided that he too was also transgender. I've known him his whole life. I've been participating a grandmother his whole life, all the way up to that time. I have never seen a sign of gender dysphoria in him since the day he was born. I even cut his cord. So when my daughter came out and said that he was transgender, I said, you know, I didn't know much about it, even though I knew the spouse was transgender, but it was the decision that she made when she was an adult. I went along with it. I supported it. I supported it when my daughter and this woman got married. And after the transition, it was when they decided to transition a 7-year-old boy. I did some research, and my daughter was very excited at the prospect of him going on puberty blockers when he was 9. And I'm like, he's not even 7 yet, and you're talking about puberty blockers. What are puberty blockers? I started to do research on them and the harms they are not reversible. Like activists and people want to tell you, I have been researching this for 4 years. Because I would not go along with the ideology, I have been cut out of his life. I have not seen him in 4 years. This whole thing destroys families, tears them apart. But besides that, just the medical aspect of what these drugs do. The thing is the WPATH and AAP all say these little children that have gender dysphoria and need the persistent stuff, they're insistent, consistent, persistent, all the way from the time they're 3 all the way up. My grandson was not that. Then you got all these teenagers that are on social media, Tumblr, all of a sudden waking up at 15, 16 saying they're transgender. And there are over 60-something gender clinics in the United States. And many of them, between them and Planned Parenthood, teenagers can walk in on the first visit and get hormones on the first visit. So a lot of these clinics are not even following their own protocol that they should be living in the life they should for like 2 years before any kind of medication. There was a doctor in California, Joanna Olson Kennedy, who got $5 million in an NHI study and started testing testosterone on 8-year-old girls because they're finding out that the puberty blockers are not working. You know, so they're finding out the puberty blockers are not helping these children because they're stunting the children when they're 10 and they're not keeping up with their peers. So they're pushing the testosterone younger. They're removing healthy breasts at 13 years old of girls who are confused, that don't want to fit into a gender stereotypical box of what it's supposed to be a female or what it's supposed to be a male. You know, what is gender anyways? And why are we medicalizing these children when 80 to 90% of them desist after they've gone through puberty?
Ms. Blanchette, are you still there?
Hi.
Blanchette, can you hear us?
I can now, but somebody muted me. Could you hear? How much did you hear?
Wait, you weren't muted. We just lost you for a few seconds. I don't know what happened, but it wasn't long.
Okay, how far did you get? What was the last thing you heard? Hello?
I don't know. You were
Okay,
talking about,
the 80 to 90, did you get the
blockers.
Did you get the power 80 to 90?
Healthy breasts were removed.
13-year-olds, they're moving healthy breasts. There is, most of the testimony I did hear, that they're saying that, oh, they wish they had that when they were a child. It's like they don't know what they would have had it happened if they were a child. And they're lucky that they got to make these decisions for themselves as an adult. The thing is children cannot consent. They just had a case in the UK. I don't know if you heard about the Cara Bell case. It was huge all the way up to the Supreme Court or whatever it is called out there. And they determined that children under 16 cannot give informed consent. Now, here in the United States, children cannot smoke, they can't drink, they can't get tattoos. There are a lot of things that children cannot do because they cannot give informed consent. So we are medically sterilizing these children and teenagers when they don't even know what they're doing. I mean, every adult in this room knows what it's like to be a teenager. Every woman in this room knows what it's like to go through puberty and how uncomfortable it is. Those are just things that are part of natural life. My personal views, I don't believe there's anything such thing as a trans child, but I do believe that children can have gender dysphoria and they can be confused about, the stereotypical things that they, if you're a little boy and you want to play with a Barbie, that does not make you a girl. You're a boy that likes a Barbie. And there's nothing wrong with that. Society needs to change what expectations we are supposed to have amongst ourselves instead of, thank you, instead of putting, you're taking these children and you're medically removing them from one stereotypical box and putting them into another when they can just be what they want to be. I absolutely oppose this bill. I mean, I support this bill, apologize. I hope you heard that correction. I absolutely support this bill. There are more and more bills like this coming across the United States. Like I said, I've been researching and fighting this for the last 4 years. I've even gone to as far as DC to push for the block of puberty blockers. This is a medical scandal happening across the whole United States, not just in New Hampshire. Thank you for your time.
Thank you. Are there any questions? Seeing none, thank you very much. Marie Landrigan.
Yes, can you hear me?
There you are. Could you please state who you are, where you're from, and who you are representing, and whether you or not you have written testimony, and you have 5 minutes.
Yes, my name is Marie Landrigan. I'm speaking on behalf of my transgender child. I'm from New York, and we often vacation in New Hampshire. I strongly oppose this bill, HB 68. Ladies and gentlemen of the committee, I am the parent of a transgender child. Oh, I'm sorry. Yes, I do have written, I've emailed my testimony. This bill that has been introduced wants to make any treatment that would alleviate the gender dysphoria in a transgender or non-binary child be illegal and counted as child abuse. This is absolutely ridiculous, not only because it would violate the rights of every single child that does not fit into the black and white gender binary that the society is currently accepting as the norm, but it would also incriminate parents who are just trying to be supportive of their children. My son who was born female, was saying that they were a boy since they were 4 years old. This is actually common, as psychologists show that children express their gender around preschool age. We tried a lot of things. I'm like a very strong feminist. I was like, well, maybe we just need to empower and make sure that they see strong representations of women, which in fact they have and were given, but that did not fix the problem. The Tinkerbell skateboards and all of that did not change the fact that my son was in fact my son. Title IX actually protects citizens on the basis of sex and gender, but also gender identity. Title IX of the Education Amendments of 1972, and in 2016, Then President Obama did make it clear that he wanted to include transgender people of all ages under this legislation. They stated then that about schools, which said a school must not treat transgender students differently from the way it treats other students. Also, I would like to bring up the fact that transgender and non-binary individuals have always existed throughout the world and throughout history. Just because in our society or our country we have maybe not heard of these people, or it's not in mainstream culture, does not mean that they have not existed. In fact, medical science has proven that there are at least 6 distinct biological sexes and any number, limitless gender expressions. Before Europeans colonized the globe, thousands of indigenous people actually acknowledged and celebrated multiple gender identities as part of their culture. A lot of this was erased when they were colonized, but there are many Native people today who do acknowledge two-spirit people and other definitions all over the globe. A famous two-spirit, Fred Martinez, for example, was not a boy who wanted to be a girl, but both a boy and a girl, an identity his Navajo culture recognized and revered as Nadlihi. Meanwhile, Hina of Komohina is a part of Native Hawaiian culture that has traditionally revered and respected Mahu, those who embody both male and female spirit. I have included in my testimony a map for reference where you can see people all over the world throughout history who have existed outside of the male-female binary. And some of these people were very revered and respected by their society as they held important roles in the society, including being healers of others. I find it heartbreaking that we are only seeing these through our narrow definition. Hormone blockers or hormone treatment can often be, but is not the only appropriate course for transgender preteens and teens. My child is now 13, so we've been doing this for 9 years. And being the research nerd that I am, I have been researching this extensively for 9 years as well. They don't just let you get hormone blockers. They make you and your child go to therapy, to many doctors, which we have gone through, and many sessions, and to make sure that the child and yourself and your parenting skills are up to par. They make sure that your child is psychologically sound and healthy. They make sure that your child is physically healthy. Hormone blockers in and of themselves simply delay puberty and are used for a variety of reasons besides gender identity as well, including precocious or early puberty in girls, especially, whose bodies are more easily affected by the pesticides in our environment and in the hormones that we eat. The most important thing is protecting transgender children. This bill is not a protection, as other people have said. It is abuse posing as protection. The rate of transgender suicide has been shown to be significantly higher than the rates for other hormones. than the rates for other youth, 5 times higher compared to their heterosexual cisgender peers. However, parents who support their children's true identities can mitigate the risk of self-harm and attempted suicide. I've quoted Dr. Caitlin Ryan in the Family Acceptance Project, which found that LGBTQ youth whose families affirm their gender identity and sexual orientation are almost 50% less likely to make a suicide attempt compared to those whose families are unsupported. Acceptance and receiving appropriate medical care and therapy can quite literally save the lives of transgender and non-gender conforming children and teens. Children know who they are and they need to be supported. Taking away the rights of transgender children is abuse. Supporting them is love. Please do not allow the hatred and ignorance of a small group of individuals who have no scientific, medical, or psychological standing overall to abuse good people, children and their parents who love them. I ask you to please vote against this bill. Thank you.
Thank you very much. Are there any questions? Okay, I see none. Thank you very much. I'm now closing the public hearing on HB 68. And Madam Clerk, can you please get ready because we're going to exec HB 68. So please let me know when you're ready.
Yes, one moment, please, Madam Chair.
Absolutely.
Madam Chair, I'm ready.
Okay, Representative Marsh and Representative Atchiller, will you be joining us? Because you have to have your cameras on to vote. Thank you. There you are. Representative Marsh?
Madam Chair, I can't start my camera. Oh, you just gave me the ability. Thank you.
There you go. Okay. All right. So this is going to be the exec session for HB 68. Representative Belanger, do you have a motion?
I do, Madam Chair. I enthusiastically move to ITL HB 68.
Do we have a second? Seconded by Representative Lewicki. Any discussion? Well, I see none, so let's go right to the roll. Oh, I'm sorry, Representative Grossman, I didn't see you. Go ahead.
Thank you, Representative Rice, for taking my question, Chairwoman. Can we just hear how many people signed in opposing, and do we have that number?
I'm going to be honest, it's not accurate anymore because of last week. I only have like this week's. I would have to do math.
Okay.
You know what I mean? Like, because last week's list was, I had stated what I can do what today's list was.
Today's list.
Somewhere. Let me find. Hold on. What did I just do with my list? Okay.
Madam Chair.
What's that?
Madam Chair, the last session was 360 people.
Okay. So today, 27 signed in support and 385 signed in opposition.
Thank you.
Okay, now, anything else? No? Okay, the clerk can call the roll.
Representative DeSimone,
Yes.
Representative Yokella,
Yes.
Representative Lewicki,
Yes.
Representative Belanger,
Yes.
Representative Marsh,
Yes.
Representative Litchfield,
Yes.
Can someone mute who's?
Representative Smith,
Yes, sorry, my husband's working next to me.
She said
sorry.
yes, Representative
Thank you. Thank you. Representative Long,
Yes.
Representative Ali Saya says yes. Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Wazir,
Yes.
Representative Petrino,
Yes.
Representative Altshuler,
Yes.
Madam Chair, Representative Rice,
Yes.
15-0.
Without objection, it can go on the consent calendar.
Thank you.
Thanks so much, everybody. That's a wrap for today. I think we've had a long enough day. Thanks so much. Have a great weekend.
Thank you, everyone.